Max, let me know when it works. Is it working, Max?
I'm not seeing anything.
Will, are you here?
Yep, I'll check. Hold on one second.
Cool. Sorry, I clicked the thing, but maybe I did this wrong.
No,
There
it should
we're
be.
on.
We're on? Great. Hi, everyone. Thank you so much for tuning in to our Rookie Rumble 2024 final round. This has been the biggest Rookie Rumble yet. This is our third year doing this tournament. We had 61 teams compete. We had 4 judges per round, and our final round teams earned a collective 31 ballots to get to where they are now. Representing the plaintiff will be team 12. Representing the defense will be team 48. And we are going to introduce our final round panel. I'm going to pass it over to Jen.
Hello, everyone. We are thrilled to introduce our 9 judges for the final round. First, we have Rhea Lockridge, is an investment analyst with JP Morgan Bank. She is a former competitor for Emory Mock Trial, winning 4 All-Americans and bringing them to multiple top 10 finishes at nationals. Rhea is also a 2-time trial by combat competitor, placing 5th and 2nd amongst the best competitors in the nation. She now lives and works in Columbus, Ohio.
Our next judge is Murray Edwards. Murray graduated from Furman University in 2003, where she was the president of the mock trial program. During her time at Furman, she was an all-regional, all-national, and 2-time All-American attorney, as well as competing at trial by combat twice. Currently, Murray is working as a paralegal in Columbia and will be starting at Drexel University's Klein School of Law as a courtroom scholar next month.
Next, we have Travis Harper. Travis competed for 4 years on the Harvard mock trial team, winning nationals their junior year. Now Travis is coaching Columbia mock trial while living and working in New York City.
Our next judge is the namesake of part of this case. Will Warahay is a practicing litigation attorney in Atlanta with Morgan & Morgan and has coached the Georgia Tech mock trial team since 2015. He competed in AMPTA with Elon University and coached Elon while he was in law school. He's been a member of the board of directors since 2013, serving as the Tournament Administration Committee Chair from 2012 to 2017, and as AMPTA's president from 2018 through 2020. Since 2021, he has served as AMPTA's treasurer.
Next, we have Dennis Kerwin. Dennis is a solutions engineer for Simplicity, an education technology company. He competed for the University of South Carolina from 2010 to 2014. Dennis went on to help coach Eastern Michigan University from 2014 to 2016 and has been coaching William & Mary since 2020. Dennis is a candidate to become a member of the board in 2026 and is also a case writer for our case that we're going to hear today, Marty Jones versus Warhater Energy Drinks.
Our next judge is Mike Galfand, who's a senior associate at Westerman, Bell, Ederer, Miller, Zucker, and Scharfstein LLP, practicing mostly commercial litigation. He competed at SUNY Buffalo from 1998 to 2001 and coached at NYU from 2002 to 2004. Since 2008, he's been coaching at Iona, where he served as head coach from 2014 to 2024. He's been an AMPTA board member since 2015 and was chair of the Civil Case Committee for the 2018 to 2019 and 2020 to 2021 seasons. He has also judged more rounds of mock trial than anybody not named Tillis or McGinnis.
We also have Anna Eldridge. Anna is an assistant professor of politics and law and director of mock trial at Rhodes College. She's been coaching there since 2008, having coached 2 teams to final rounds in 2013 and 2019. Before joining the faculty at Rhodes, she was a civil and criminal trial lawyer. She competed in mock trial for Rhodes, participating in a final round in 2001. In 2023, she received the Neil Smith Award. We also have Jacinthe Sohi. Jacinthe is the Director of Enterprise Marketing at Found. Jacinthe is in her first year as president of AMTA. She's a former competitor for Claremont McKenna College and joined the board of directors in 2019.
So thank you again to all of our judges for judging. We've really got an excellent panel for you all this evening. And I'm now really truly honored to introduce our presider for this evening. Our presider was an All-American witness for Rhodes College in 2003 and previously worked as both a public defender and a civil rights attorney. But you all probably know her better currently as the elected representative for the 30th District of Texas, which includes much of Dallas. So I am pleased to announce our presiding judge for this round, Congresswoman Jasmine Crockett. Congresswoman Crockett, I'm going to pass it over to you. And with that, we will be ready to start this trial.
Absolutely. Well, thank you so much, Max. Thank you so much to each of the competitors. I look forward to hearing your presentations. And so with that, I will not belabor. Counsel for the defense, will you please introduce yourself?
Yes, Your Honor. Good evening, Your Honor. Good evening, everyone. My name is Kobe Ackerman. Today, I'm joined by my co-counsel, Miss Penelope Stinson.
Good evening, Your Honor.
And Miss Emberlyn St. Hilaire.
Good evening, Your Honor.
Good evening.
Together, we represent the defendant in today's case, War Hater Energy Drinks.
Thank you so much for that introduction. And plaintiff, this is your case, so please introduce yourselves.
I'd be happy to, Your Honor. Good evening. My name is Lorelei Tang, and today I'm joined by my co-counsel, Ms. Sophia Letty.
Good evening, Your Honor.
Good evening.
And Ms. Lydia Ferris.
Good evening, Your Honor.
Good evening. Well, thank you so much for those introductions. At this time, plaintiff's counsel, do you have an opening statement?
Yes, Your Honor, but before that, we have a couple of pretrial matters to attend to.
Absolutely. Please proceed.
Yes, Your Honor. Now, at this time, the plaintiff invokes Midland's Rules of Evidence 603 and 615. These just constructively swear in and sequester all witnesses other than party representatives.
Defense counsel, any objections?
No objections, Your Honor. We just want to note for the record that we don't have a party rep in today's case.
Absolutely. Thank you so much. Those rules have been invoked. Anything else, plaintiff's counsel?
Yes, Your Honor. For the record, Marty Jones, the plaintiff, will be present throughout trial as our party representative.
Thank you so much.
Secondly,
Anything else? Okay, go ahead.
yes, Your Honor. Secondly, we understand that this case can be quite complex, so we'd like to put the court on notice that we're bringing this suit under an act in this jurisdiction called the Midlands Unfair and Deceptive Trade Practices Act. Permission at this time for the trial tech to share a copy of the plaintiff's complaint?
Permission granted.
All right, Your Honor, as you can see on the screen here, while we understand that there are multiple ways to prove that a defendant violated this act, the plaintiff is only responsible for proving one. For today, the plaintiff will be focused on proving prong 14L, that the defendant was operating as a pyramid scheme.
Thank you so much.
Secondly, we'd also like to point out a relevant case law. Permission to share that as well?
Yes, you may proceed.
Now, according to your predecessor, who ruled on Cali v. Crowley Way, pyramid schemes violate this act because they're both unfair and deceptive by nature. Now, to be clear, we don't need to prove it's not part of the plaintiff's burden, to prove that the company was both a pyramid scheme and deceptive, just that they were a pyramid scheme since they are inherently deceptive.
Anything else?
One last thing, this case law also defines a pyramid scheme as an organization that makes most of its revenue based on recruitment instead of sales.
Defense counsel, having heard the presentation of the case law by plaintiff's counsel, do you have any response or any objections?
Yes, Your Honor, we have a couple of pieces of case law we'd like to mention on our own as well.
All right, please proceed.
So before I get into that, Your Honor, because no rebuttal witnesses are allowed in this jurisdiction, both parties have come to the agreement upon a character evidence form. If I could put that in the chat for Your Honor's benefit.
That would work out.
Let me know when you've received it.
I have it.
All right, great. A couple more things we'd like to note for the record. I'd like to direct the court's attention to a pretrial ruling in today's case. Permission to put that on the screen right now.
Permission granted.
Your Honor, we're going to be calling an investigator to the stand. He investigated this company in 2020, and we'd just like to note for the record that even though his investigation was 4 years ago, it will not be barred as improper character evidence. Now, Your Honor, we have two other pieces of case law we'd like to mention, if I could put those on the screen as well.
Proceed.
So first of all, we want to direct the court's attention to a case law called Thesis v. Palacios. What this says is that part of the plaintiff's burden is to prove that the defendant's conduct was the direct and proximate cause of the plaintiff's injuries. Secondly, Your Honor, to respond to the plaintiff's piece of case law, Cali, we just also like to note for the record that while Cali defines what a pyramid scheme is, it also defines what a pyramid scheme isn't. And as you can see at the bottom, it mentions 4 prongs specifically to what a legitimate business is. Now, Your Honor, besides that, the defense is ready to rumble. Your Honor, I believe you might be on mute.
Sorry about that. Plaintiffs, are you ready to rumble as well?
Yes, Your Honor, we are.
Very good. Plaintiffs, you may proceed with your opening statement if you have one.
We do indeed have an opening statement, Your Honor. Permission to proceed when ready.
Please proceed.
The real money is in recruitment. It's 2017 and the CEO of Warhater Energy is staring at a spreadsheet covered in red. She needed her startup to make millions. And she's not even close. Sales just aren't enough. And then the light bulb goes off. You'll learn that she turns to what's called recruitment. Salespeople are rewarded for bringing other sellers into the company. Everybody has to buy the product. So maybe, just maybe, the CEO will finally turn a profit. But there's a problem. Her business plan isn't new. The CEO has made Warhater Energy a pyramid scheme. And that's illegal. She closes the door to her office, pushes her doubts out of her mind, and starts drafting a memo. You'll learn that she knew her employees would lose money, but she didn't care. Because the real money is in recruitment. That's why one of Warhater's victims, Marty Jones, has brought a claim against the defendant. Now, with that claim, my co-counsel and I promise to prove to you that Warhater violated Trade Practices Act. To demonstrate this, we'll be proving that Warhater was a pyramid scheme. That is, it's more likely than not that the employee's real money is made in recruitment, not in sales. But your job today, members of the jury, isn't just to tell the defendant they broke the law. It's to make sure that they don't do it again. That's why the plaintiff is also seeking what's called punitive damages. To get those, we've got to show you clear and convincing evidence that Warhater knew what they were doing was wrong and chose to do it anyway. And to do this, we're going to show you three things: the saleswoman, the structure, and the strategy. First, we'll bring you the saleswoman. We'll introduce you to Marty Jones. She's a college student who thought she could help pay for her education by selling for Warhater. She tries and tries to sell, but nothing's working. She's falling further and further into debt. But what she doesn't realize, what the company doesn't want her to realize, is that the business just isn't set up that way. Warhater set her up to fail. And that brings me to our second fact: structure. Warhater is a pyramid scheme. To prove this, we'll speak with Dr. Elmore, an expert in business practices. She'll tell you how Warhater's structure matches the structure of a pyramid scheme. That's the reason why Marty Jones couldn't make any money. And finally, we'll show you our third fact, that this was the company's strategy, that this was intentional. We'll introduce you to Chris Rone, another victim of Warhater. And she'll tell you she heard the CEO admit on a private Zoom call the only real way to make money was by recruiting others. Members of the jury, what the defendant did was wrong. Because the real money was in recruitment, hundreds of sellers lost thousands of dollars. Because of this, we'll ask you to find the defendant liable for illegal business practices at the end of trial today. Thank you.
Thank you so much. Defense counsel, do you
Yes.
have an opening statement that you'd like to give at this moment?
Yes, Your Honor, we do. Permission to proceed.
Permission granted.
Thank you. Your Honor, Ms. Letty, members of the jury, Warhater was up front, but the plaintiff's sales fell behind. Every month, restaurants across America open and close. Every week, people bet on stocks and lose. And every day, people take risks, hiring employees, buying inventory, selling products, knowing that those risks, well, they might not pay off. Because that's the nature of business. There's no surefire bets. And just because you've lost money, well, it doesn't mean that you've been wronged. And that's what today's case is about. Because Ms. Letty just got up here and told us that the real money was in recruitment at Warhater, that Warhater is some kind of pyramid scheme. Now, that means today that they've got to show you that the primary source of income at Warhater was recruitment over sales. But they're not going to be able to do that because the evidence is going to show today that Warhater is a legitimate company, that they sell energy drinks through essentially independent contractors, and that they're upfront about risks and upfront about potential earnings. And all of that information, well, that's a problem for the plaintiff because today they have the burden in today's case, and they've got to show you that two things are more likely than not. First, that Warhater actually deceived Ms. Jones. And second, Miss Jones suffered damages as a direct and proximate result of that deception. But we expect they're not going to be able to meet their burden today because of two questions we, as the defense, we want you to consider as we go through trial. First, was Worry Hater up front? And second, if Worry Hater was up front, why did the plaintiff lose money? Okay, let's break that down a bit. Let's start with that first question. Was Worry Hater up front? Because you're going to learn today that the answer, it's yes. We're going to call a financial investigator, someone named Vade Vasudan. Now, he investigated Worry Hater, and he's going to tell you that they disclosed all of the necessary information to sellers. And you'll actually get to see those disclosures for yourself. Okay, so pretty simple answer to question one, check, yes. And that takes us to question two. Why did the plaintiff lose money? Because today, the plaintiff has to show you that Miss Jones lost money as a direct result of the actions of Worry Hater. But what you're going to hear instead is that Miss Jones lost money because of her own risky business decisions. We're going to call a different Worry Hater salesperson, a woman named Dylan Starr. Now, she's going to tell you she was able to succeed selling Worry Hater. She's going to tell you what Worry Hater told her, which is that earnings were based on effort. And if that's not enough, you're going to hear it straight from the source. We're going to call the CFO of Worry Hater, a woman named Ruben. She's going to tell you what they told sellers, which is that successes and failures, well, they depend on you. Because at the end of the day, there's a difference between a business that forces you to lose and plain old business losses. Miss Jones, she had business losses. And that's why at the end of today's trial, my co-counsel, Miss St. Hilaire, will ask you to find our client Worry Hater not liable. Thank you.
Thank you, counsel. Plaintiff, you may proceed with your first witness.
Yes, Your Honor. The plaintiff calls Marty Jones to the stand. May I proceed?
You may proceed.
Good evening. Could you please introduce yourself to the members of the jury?
Good evening. My name's Martha Jones.
Where are you from?
I'm from this little town in Georgia called Atlanta, if you've ever heard. But I moved here to Midlands a few years ago for grad school.
Where do you go to school?
Midland State. I'm getting my PhD in developmental psychology.
How's that going?
I'm taking some time off right now. I ended up needing more time and money than I thought to finish my degree. So right now I'm just working on campus, trying to save up to go back to school.
Miss Jones, why are you here today?
A few years ago, I worked selling for this company called Worry Hater. They're an energy drink brand, kind of like Red Bull or Monster. I got roped in, lost a whole lot of money. I'm here to talk about my experience.
Let's start at the beginning. How did you start working with the company?
There's this girl in my classes, Kate. One day, she told me she was a recruiter for Worry Hater. I started giving her a sales pitch right in the middle of our lecture.
Well, after you tried recruiting you, did you accept her offer?
Not at first, ma'am. But around beginning of 2022, about 2 years ago, my student loan payment started coming up. I was strapped for cash, so I started working for Warhater on the side.
What did you first do after you started working for Warhater?
My recruiter told me that before I could do anything with the company, I had to pay them $3,500. So I did.
What was the $3,500 for?
The way the company was supposed to work was that I would buy all these energy drinks in bulk for cheap from the company. And then I'd mark the prices up and sell them off to people. The $500 was supposed to be for advertising materials, and the $3,000 was all energy drinks. They said that was the minimum initial investment.
Ma'am, after buying $3,000 worth of drinks, how did you go about selling your supply?
I did everything my recruiter told me to do. I mean, I set up social media pages. I set up a little stand outside campus events. I even hosted review sessions during exam seasons like finals or midterms, so I could get all my caffeine-hungry classmates in one spot, sell my drinks.
Were any of these efforts successful?
Some. I never ended up making back the money that I spent.
So what happened after that?
I went back to my recruiter. I told her I just couldn't sell so many cans. And then she told me I had to keep ordering more. She said if I didn't order at least 3,000 cans a month, or $3,000 worth of cans a month, I couldn't stay active with the company.
Objection, Your Honor, at this time to best evidence. May I be heard?
Yes.
Yes, Your Honor. Right now, the witness is referencing statements specifically in the company's financial disclosure packet that outlines exactly the requirements regarding being an active seller. Right now, it's our contention that she's mischaracterizing those statements. We'd ask that the document be entered into evidence so it can speak for itself.
Plaintiff, do you have a response?
Yes, Your Honor. We could bring up Exhibit 2 if necessary.
Not the response I thought, but okay. Then proceed. Let me ask you, let me clarify. Defense counsel, you there?
Yes, Your Honor.
Are you trying to impeach this witness? Because it sounds like you're saying that the witness is testifying in a way that is not conforming with the actual evidence. Are you attempting to impeach her with this document?
Your Honor, not at this time. Right now,
Okay.
pursuant to Rule 1002, it just states that if we have the original writing of a document, in order to prove its contents, it should be entered into evidence. We have it on a good faith basis that the statements this witness is referencing from her recruiter come from a document which we have. The document can speak for itself.
Response, Your Honor, on those counts.
I'm sorry, what was that, plaintiff?
Response, Your Honor.
Yes, please proceed.
Now, if that's the defense's argument, then that exhibit isn't needed for this testimony to be elicited. Ms. Jones is testifying to her own personal knowledge. This is what she knew when she was working at the company. In fact, she's the person that was buying the $3,000 every month. The exhibit isn't needed to understand what Ms. Jones is saying.
Response, Your Honor? My
This will be
apologies.
the last. Go ahead.
Yes, Your Honor. It's just that pursuant to Rule 1002, this witness is testifying to statements from a document which we have. It's better for the document to speak for itself so there's no mischaracterization as to what it says.
Thank you. At this time, I'm going to overrule the objection. If I am thinking back to the testimony, it seems as if plaintiff's counsel was leading the witness through her own experiences. Now, you will have an opportunity to present this document in your case in chief if for some reason the plaintiff does not bring that document up. And you also will have an opportunity to cross-examine if for some reason you feel as if she has mischaracterized information that is in that document. At this point in time, plaintiff, you may proceed.
Yes, Your Honor.
Now, ma'am, I don't believe you got to finish. Now, what happened after you found out that your efforts to sell weren't successful?
I went back to my recruiter for help, told her I couldn't sell at all. And then she said I had to keep selling, or I had to keep buying from the company at least $3,000 per month if I wanted to stay active with them.
How long did this go on?
Over a year. Same thing each time. I couldn't sell it all. I went back to my recruiter for help, and she told me I had to keep buying to stay in the company, to stay active.
What happened after you kept buying these cans for months, over a year?
I just couldn't do it anymore. I mean, I put so much time and effort and money into this. I wasn't seeing any of it back, so I got out.
Well, let's talk about why you weren't able to profit off of selling. Now, besides selling, do you know if there were any other ways to make money in the company?
Yeah. You could also recruit other people to join. They pay you for that too.
What do you mean by they'd pay you for that too?
When I would get someone else to join the company, War Hater would pay me around $250 per person. And then if I could get those people I recruited to keep buying more from the company too, they pay me extra, like a bonus.
How did you learn about these recruitment bonuses?
My recruiter. I went back to her, told her about how I wasn't making money in the company. And she said it was because the real money was in recruitment.
Objection, Your Honor, at this time to 403. May I be heard?
Yes, please proceed.
Yes, Your Honor. This statement is substantially more misleading than it is probative. If I could turn your attention to a piece of case law, I can screen share it for Your Honor.
Yes, please.
Perfect. I'm referring to the case Figo v. Roca. It states that misstatements by a single independent contractor that aren't endorsed or encouraged by the company cannot be used to create liability under the Unfair Trade and Practice Act. It's our contention in today's case that this statement does not line up with company goals or was encouraged by the company. And without that foundation that it was, it's substantially more misleading than it is probative because it misleads the jury into thinking that this was War Hater's policy.
Response from plaintiff's counsel.
Yes, Your Honor. First of all, case law Figo v. Rocco is with respect to liability, not admissibility. Whether or not misstatements are an indicator of the liability of the defendant, that's what that case is for. Now, in response to whether or not this was aligned with the company's goals, if I may proffer.
I guess. I kind of want to stick to the objection, which I understand why you're attempting to do the proffer. But unless defense counsel has something else to add, I think that I'm ready to rule on the objection in general as it relates to the admissibility of this particular statement that was just made. As I hear it, the objection itself was probative. That was the objection, correct? Defense counsel?
Yes, Your Honor, so that this statement is substantially more misleading than it is probative under 403.
Yes, prejudicial versus probative. Got it. And I am going to overrule that at this time. Again, you will have an opportunity on defense where you can go into it. And we will allow the jury the ability to determine the probative value and how much weight they want to give to this witness's testimony. I don't think it's just over the top prejudicial at this point. But please feel free to make another objection if you feel as if it is reaching that point. Okay.
Yes,
Plaintiff's counsel, you may proceed.
Ms. Jones, what did Catherine tell you about the recruitment structure of the company?
She said that the recruiting was where the real money was.
All right, now, ma'am, I want to make something clear. Over the course of your entire employment at War Hater, Just how many cans of drinks did you sell?
By my count, over that year, I sold over 17,000 cans of those energy drinks.
After selling 17,000 cans, how much did you profit?
I didn't. I lost money.
At any point, did you ever try to get your money back?
Of course. I went on the website. It said it promised me a refund if I couldn't sell on my cans. So I submitted that refund form. I tried to get my money back.
Did the company ever give you your money back?
No, not a penny.
Thank you so much for your time today, Ms. Rone. No further questions.
Cross-examination,
Yes, Your Honor.
you may proceed.
Good afternoon, Ms. Jones.
Good afternoon.
Ma'am, I want to talk about if Laura Hayter was upfront with you. Because you received a financial disclosure packet from Laura Hayter, right?
That's correct.
You read through it.
I did.
Your Honor, permission to screen share Exhibit 2? Yes, Your Honor.
It's granted. Sorry.
Ma'am, this is that disclosure document, right?
That's right. This is one of the pages in the welcome packet they gave me.
It hasn't been changed or altered in any way.
That's right.
Your Honor, at this time, move to enter Exhibit 2 into evidence.
Any objection?
No, Your Honor.
So admitted.
Ma'am, let's talk about if what you said on direct examination is consistent with what's in here. Because, ma'am, the first paragraph explains the War Hater business opportunity, right?
Sure.
It doesn't say the real money is in recruitment, does it?
No, that's what my recruiter said. You're right.
Ma'am, that's a yes to my question. It doesn't say that here.
Yes, ma'am.
It says we don't pay sellers to recruit.
That's what it says here, yeah, but if you recruited more people, you'd get $250.
Ma'am, I'm gonna need a yes or no to my question. It says we don't pay sellers to recruit.
Sure, that's what it says.
It says, remember, you're here to sell energy drinks.
Yes, ma'am.
It says, while we give bonuses for recruitment, your primary income should come from product sales, right?
That's what they said at first. You're right.
Ma'am, from the very start, your recruiter, Miss Marlowe, told you to focus on selling as many drinks as you can. Sure.
That's what she said at first. You're right.
Then let's talk about if they were upfront about earnings. We can get Exhibit 2 back up. Ma'am, they disclosed to you that the typical seller only made $172 annually, right?
They did.
They told you this didn't include business expenses.
That's right, ma'am. That's what I see.
They told you they can't guarantee any type of earnings.
Yes, ma'am.
That your success or failure depends on your own skills and your own personal effort. That's what they told you.
That's what it says, ma'am. You're right.
So, ma'am, after reading these disclosures, you chose to be a seller at War Hater for 14 months, right?
That's right, ma'am. After I learned that they would refund me any of the money that I spent, I chose to sell for them.
We'll get to the refund in a moment, ma'am, but that's a yes to my question.
Yes, ma'am.
After reading the average seller made $172, you spent $21,000 on inventory. True?
Over a year, that's what they said I had to do. That's correct.
Well, hold on, ma'am. You knew at the time you didn't have to buy inventory every month, right?
They said I had to buy $3,000 of inventory each month if I wanted to stay active with the company.
Oh, let's be clear. Miss Marlowe, she didn't tell you they would kick you out of the company if you didn't buy monthly.
No, she didn't.
She didn't say you couldn't sell existing product if you didn't buy monthly.
No, she said I had to buy more product if I wanted to stay active with the company.
What she told you was that it's only necessary if you wanted to be eligible for bonuses, right?
If you wanted to be active, that's right.
That's what being an active member meant, only being eligible for bonuses, right?
That's right, ma'am, for recruitment bonuses.
That's what Miss Marlowe told you, and that's what the War Hater packet told you too.
That's right. It was only 3 or 4 months later, after I started working for the company, that she explained the $3,000 was for recruitment. You're correct, ma'am.
Ma'am, despite knowing you didn't have to buy monthly, you did, right?
Yes, ma'am.
Even though you weren't selling fast enough.
That's correct. The company said I'd make it all back.
Ma'am, at no point during those 14 months did you step back from the company, did you?
No, I quit over a year in. You're right.
So, ma'am, if that was the case, let's talk about why your sales may have fallen behind. Have you ever heard the phrase, don't get high on your own supply?
Yes, ma'am, I have.
Ma'am, the truth is, you would consume inventory you were supposed to be selling.
I drank one energy drink a week, if that's what you mean.
Well, ma'am, you thought the drinks were addictive, right?
Sure, they were caffeinated, that's right.
Every month you would set aside a pack just for yourself, true?
Yeah, a 6-pack. I drink about 6 drinks a month. I was a college student then.
Instead of selling it for a profit, right?
The one 6-pack?
Ma'am, you put aside a 6-pack every month that you were a seller, right?
Yeah, I put aside one 6-pack a month. The one that I would drink instead of sell. That's correct.
So that's yes to my question. You wouldn't sell it for money, would you?
Not that 6-pack, no.
Well, and it doesn't really stop there, does it, ma'am?
Does what stop?
Well, let's talk about if you put in as much work as you're telling us you did. Because at the time you were a seller, you were a busy student, right?
Sure. I was still in school then.
You didn't go to a single sales training.
No, they didn't offer me that.
Ma'am, that's a yes, you didn't go to a training.
No, I didn't.
You don't have phone records or emails contacting potential buyers.
No, ma'am. I did all my selling in person.
Ma'am, you said on direct that you did review sessions, was it?
Yeah, I hosted review sessions on campus.
You don't have pictures of you at any of those review sessions?
Well, I'd advertise them on social media.
You also don't have screenshots of those posts you just mentioned in court today?
No, not in court, ma'am. They're on my Instagram.
So that's a yes. You don't have them with you to show us?
No.
Ma'am, no witnesses come and testified and said, yeah, I saw Miss Jones trying to work hard to sell those drinks.
Ma'am, I don't believe there have been any other witnesses.
Ma'am, all this to say, when you tell us you put in 50 hours of work a week, all we have is your word. True?
I did put in 50 hours a week. You're correct.
Ma'am, that wasn't my question. All we have is your word, right?
I suppose so. You could ask anyone you wanted, ma'am.
That's a yes to my question, ma'am.
I don't know. You could ask the people who've come to my review sessions. If you wanted more proof, you could.
All right, ma'am. Well, let's quickly talk about those refunds you mentioned. Because you said you applied for a refund and didn't get one. Did I get that right?
That's correct.
Well, you contacted War Hater for that refund, true?
Yes, ma'am. After I sent back all my products to the company, they emailed me saying that if I didn't sign an agreement that said I couldn't disparage or sue the company, I wouldn't get my money back.
Well, let's make this clear, ma'am. At some point during that process, they asked you to send in serial numbers, right?
Sure. They asked me to send them serial numbers, I said it would be a lot of work for me to do, so they agreed to check them themselves if I sent the product over.
Oh, I just need to clear this up. They gave you instructions for what to do to get your refund, right?
Sure, they said that if I wanted to get my refund, I had to sign that agreement saying that I couldn't sue them.
That's right, ma'am. And you made the decision not to sign, right?
Of course not. I wasn't signing away my right to speak out with the company or to sue them. I didn't sign that. You're absolutely correct.
Right, ma'am. So after you made the decision not to comply with their instructions, you didn't get a refund. That's true, right?
That's right. By that time, I'd already sent all my energy drinks back. They didn't give me my refund.
Thank you, ma'am. No further questions at this time.
Plaintiff, any redirect?
Yes, Your Honor.
You may proceed.
Ms. Jones, you just asked a couple questions about how you were falling behind in sales because you were consuming your products. How many packs did you have to sell each month?
I bought maybe it was $3,000 worth of 6 packs a month. Each 6-pack was about $20.
So how many of those 6 packs did you set aside to drink per month?
I set aside one.
Now, besides those 6 drinks that you drank every month, how many total drinks did you end up selling while you were working at War Hater?
17,000, ma'am.
Thank you. No further questions.
Thank you. You may call your next witness.
Plaintiff calls Dr. Alex Elmore to the stand. May we proceed, Your Honor?
Oh, you may proceed.
Good evening.
It's afternoon for me, so good afternoon.
Could you please introduce yourself to the members of the jury?
Of course. Hello, my name is Alex Elmore, but today Dr. Elmore is just fine.
What do you do for a living?
I'm a professor of organizational psychology at UCLA.
What's organizational psychology?
Yeah, I get that a lot. Basically, we study certain business structures and how it might interact with our own psyches and psychological processes.
How did you get into this kind of work?
Well, back in undergrad, I took an odd psychology course because there was a girl I liked in the class. And during that semester, I fell in love with two things, psychology and my future wife.
So, Dr. Elmore, what credentials do you have as an organizational psychologist?
I've got a bachelor's in international business, a master's in social psychology, and back there's a PhD in organization studies. Past 24 years, I've been a financial consultant and a professor.
What's your role in this case?
Well, I was asked by plaintiff counsel to look into a business called War Hater Energy Drinks and look at its business structure in relation to predatory business practices and pyramid schemes.
What materials were you given to review in preparation for this trial?
I looked at the affidavits of War Hater sellers, several people in the C-suite, financial disclosures from the company, and then I conducted some additional background research on my own.
Did you have a method for all of that?
Yes, I performed what's known as a comparative documentary analysis.
Is that method reliable?
It's the gold standard in my field.
Did you reliably apply it?
I did.
All right, so Dr. Elmore, you told us that you were here to talk about pyramid schemes. Can you start by defining what it is?
Sure. Pyramid schemes are part of a classification of business structures that we call greater fool schemes. The only way to make money is to convince somebody else to buy into the business. That's who the greater fool is.
Is this legal?
No.
Objection, Your Honor. Improper opinion under case law diamond design. May I be heard?
Go ahead.
Your Honor, if we're allowed to put the case law on the screen right now, I can explain.
You may proceed.
I believe it's coming up. What the case law basically says is that witnesses are not allowed to say whether something's legal or illegal. They're not allowed to make legal conclusions in today's case. And that's what this witness is doing, responding to the question, is this legal?
Plaintiff's counsel, your response?
Your Honor, that's not quite what this case law says. This case law draws a distinction between just defining whether or not something is legal and then applicating that into something that is present for the jury, something that they are going to rule on. In this situation, Dr. Elmore is saying that pyramid schemes, they're not legal. This is a fact that everyone agrees on. What this case law sets out is that Dr. Elmore can't say that this company is in fact an illegal pyramid scheme. That's the distinction here.
Defense counsel, go ahead.
We've heard extensive foundation about this witness's expertise. They never mentioned that she has a law degree, that she's practiced law at all. Her expertise is in psychology and not law. And as we can see in the first line of this case law, it says they should not offer legal conclusions or legal interpretations. Now, sure, she's not saying that what they did in this case was legal, but she's not qualified to mention what anything is legal or illegal in today's case.
Okay. The testimony, run it back for me, that you are objecting to, because I have a feeling on which way I'm leaning, but I'm trying to make sure I give everybody the benefit of the doubt. The exact testimony that you think is objectionable is that the doctor testified that pyramid schemes are illegal. Is that correct?
Yes, Your Honor. I believe the question was, is this legal? And the doctor testified no.
Okay. Pyramid schemes, though, correct?
Yes. Yes, Your Honor.
Okay. So, is defense counsel's position that pyramid schemes are legal?
No, Your Honor. However, we do acknowledge that part of the defense's burden is to prove that this company is a pyramid scheme. And it is for the jury and the jury to alone to decide whether this company is and whether that's a legal violation, not for the doctor.
I understand. Plaintiff's counsel, let me be clear. So I am going to overrule your objection. I am going to instruct the witness that any testimony that you make cannot specifically state whether or not the ultimate issue has been reached in this case, because that is up to the jury to decide. So as far as making the official legal conclusion that this was a pyramid scheme, you are not allowed to say that. Now, if there is foundation that plaintiff wants to lay as it relates to expertise, and if there's anything that you testify to as it relates to your actual expertise, that is perfectly fine. But as it relates to the ultimate conclusion in this case, that will be left to the jury. Do we understand?
Yes, Your Honor. If I could ask a bit of a clarifying question.
Go ahead.
Your Honor, is the line being drawn where Dr. Elmore, what she can't do is say that this company is in fact a pyramid scheme, and that's where the line is?
Not in fact, but if for some reason you lay the proper foundation that in her expert opinion, if you are quantifying this witness as an expert, this expert can testify to things within this expert's realm, and it has to be couched that it is within their expertise and it's just their expert opinion. That way the jury understands that it's not going to the ultimate conclusion, but they understand that they're testifying only as it relates to their expert opinion.
Sounds good, Your Honor.
Does that make sense?
Yes, makes perfect sense.
Okay. You may proceed.
All right, Dr. Elmore, what does the structure of an illegal pyramid scheme look like?
Well, it can be kind of difficult to just sort of explain. So I've got a little bit of a visual and my wife actually helped me make. She's a graphic designer.
Your Honor, Dr. Elmore is going to screen share that visual for us.
You guys all see that correct?
I see that
Yes.
just fine. All right, what do we have here?
Well, this is going to be the structure of a hypothetical pyramid scheme. As we can see, there's somebody who's already joined the company. And for no reason at all, let's call him Abby. Now, Abby's going to have to buy a product. And when she does that, she's going to have to pay a fee. She's losing money.
So if Abby is losing money, how is she going to make some?
On a pyramid scheme, it would be by recruiting. Let's say Abby recruits 2 people into the company. When those people buy that product, well, Abby's going to get a bonus for that. Doesn't have to stop there, because if her recruits also recruit people, when they buy the product, Abby also makes a bonus off of those 3rd tier of recruits. The cycle can keep going infinitely.
Now, is this process predatory?
It is. It's predatory because the design of the business forces people at the bottom to lose money, and everyone else on the top is getting rich off of them.
Thank you for that visual, Dr. Elmore. All right, we talked about what the structure of a pyramid scheme looks like. Now, let's talk about what Warhater's business structure looks like. For this case, were you able to analyze Warhater's business structure?
Yes, I've got another visual for the data.
Sounds good. Your Honor, Dr. Elmore is going to screen share a second visual.
Go ahead.
All right, what do we have here?
Well, this is going to be one of Warhater's financial disclosures that they give to all the sellers at the company.
Okay. Do you recognize this document?
Yes, it's part of what I used in my analysis of Warhater energy drinks.
And in that document, does Warhater explain their business structure?
Yes.
Could you elaborate on what that structure looks like?
Sure. We're going to look at this chart down here. It's going to explain that Warhater has 4 levels of employees. Now, that first level, the initiates, they're going to be people who have just joined the company. The 3 other levels, those are going to be levels that you get promoted into.
How do you get promoted into these levels?
You get promoted for recruiting people into the company. I believe the apprentice has a threshold of 6 people, and the ambassadors is going to be 25.
And when you recruit people in this company, are you rewarded?
Yes. There's 2 ways you get rewarded for recruiting. First, there's a flat bonus you get every time you recruit somebody into the company. It's going to be $250. And then there's a scaling bonus you get every time one of your recruits or their recruits buys a $3,000 worth of energy drink product.
All right, I want to focus on those initiates who haven't been promoted for recruitment. How much of the company do they make up?
Sure. So those people are going to be making up 63% of the company. That's going to be that purple section. The gray section are sellers who have been promoted for recruiting.
If initiates make up 63% of the company, how much are they making in total earnings?
Well, a little bit of math. If you look at the left side of the screen, we're going to multiply each tier's proportion of the company by the average amount of money they're going to make each year. And as you can see, despite being 63% of the sellers, those initiates are only going to be making 6.4% of the total profit.
Under Kane's software, this is an improper opinion. May I be heard?
Yes.
Your Honor, Kane's software is a piece of, if we could get the demonstrative off the screen for a little bit. Thank you. Kane's software is a piece of case law in this jurisdiction. It says that trial by ambush is not allowed. What that means is the witness can't testify to any conclusions they don't include in her report. Now, this sort of math, I believe we're getting it up on the screen for you, Your Honor. There it is. This sort of mathematical analysis that the witness is applying right now, that's not included anywhere in her report. That specific number, 6.4, is not in her report.
Plaintiff's counsel?
Your Honor, if we could
Response?
actually Yes, Your Honor. Sorry about that. Your Honor, if we could just focus on that case law that's actually right before it. It's called Agarwal v. Samani. It came out in 2020. This Midland Supreme Court ruling, it actually is a very important line that it explains why this is allowed. It states just in that middle portion that experts should not be expected to include in their reports every basic scientific fact known to layperson and to known realities that support that conclusion. And so, Your Honor, that also includes facts from a specific document, so long as the expert explicitly disclosed that they relied on that document in forming their opinion, and that document was made to the other party through discovery. Now, we've already established that Dr. Elmore relied on Exhibit 2, and that's where she did all that proportion math stuff to get that number for us.
Response on those
Okay.
grounds.
Go ahead, and then I've got some questions.
Yes, Your Honor. Okay, so to clear a couple things up, what Agarwal v. Samani says is that basic scientific facts and data don't need to be included in the report. The example that the case law uses is Newton's law. That's a basic scientific principle that an expert wouldn't need to include in their report. This is completely different. This is a case-specific analysis. If the witness wanted to testify to this specific number, 6.4, pursuant to Keynes software, they had to include it in their report because it's a conclusion.
Okay, so here's my question. Because I don't know how you came up with 6.4. I mean, the general rule is this. Yes, you don't have to include every simple thing, right? But if I can look and I can see 2 plus 2 equals 4, then that's not a surprise. But I honestly don't know how you got to the 6.4. So if you can explain with just using the 4 corners of the exhibit, I believe it's exhibit, I think it's exhibit number 2. If you can explain how you got there just using that exhibit, then I will allow it. If you cannot explain how you got to 6.4 by only using the information that's available on that document, then it will be disallowed.
Absolutely, Your Honor. So, Your Honor, would you like us to clarify that by asking Dr. Elmore how she reached that proportion using Exhibit 2?
That would work. So just to be clear, my ruling as of now is that it is overruled unless the doctor cannot explain without going outside the parameters of this document. If this doctor has to go outside these parameters, then it will be sustained and we will strike the testimony. So please proceed, plaintiffs.
Yes, Your Honor. So Dr. Elmore, if we could get that visual back up again with Exhibit 2.
All right, that might take some finagling to get back to where we were supposed to be. Let's see. Would you like this?
Yes, that is perfect. So Dr. Elmore, you mentioned earlier that you reached that 6.4 percentage. Could you explain to us how you did the math to get to that 6.4 using that document?
Sure, I actually will go forward in this slideshow. So as you can see, there's going to be 2 columns here. There's the percentage of sellers at each level and the average annual earnings. Since the percentage of sellers are flat numbers and they add up to 100, we can make the proportions a singular seller. So there's going to be 63 people who are making $223, 25 people who are making $1,768, 8 people who are making around $9,000, and 3 people making around $34,000. You can add that up and then divide by the number of sellers. It's just a simple average.
All right, if we could go back to that pie chart.
Objection, Your Honor.
Yeah, I'm smelling what you're putting down. Hold on, defense counsel. Give me 2 seconds. Cause y'all, I'm looking at this document on my iPhone now. Did it say how many sellers on that document?
Your Honor, I believe that
Plaintiff.
Apologies. I believe that it does lay out a percentage of the sellers in the company. Let me check what column that is. You could just give me a moment to pull it up on my end.
Your Honor, I'm pretty sure we have it on a good faith basis. It doesn't.
So your apologies.
Go ahead.
So Your Honor, that second to last column, it says percentage of sellers at this level. That's the number that Dr. Elmore is using. That's the percentage of people at this level that the company lays out.
Correct. I understand that part, right? But my question is, do you know how many sellers there are, like the raw number of sellers, to know what that 63% actually represents, to then be able to come to the conclusion that we're arriving at 6.4% of those that are, what does that say, initiates?
Sorry, Your Honor, I'm not that good at math, so I see what you're saying now. No, we don't know that the actual literal number of people. This is an average that is based on that percentage, and we can have Dr. Elmore clarify that if that's needed.
I'm not getting to 6.4. I'm not getting to 6.4. And because no one has made it plain how we get to 6.4, I am going to, at this point in time, have to sustain defense counsel's objection, because that would be unfair surprise for them. And with that, I also am going to order that this particular portion of the doctor's testimony be stricken.
Your Honor, point of order.
You may proceed. Go ahead.
We also asked for a curative instruction to instruct the members of the jury to disregard that chart that was on the screen that displayed 6.4, in addition to striking the testimony.
That's granted. Anything else, defense?
I'm done, Your Honor. I'll be quiet now.
No, do what you're supposed to do. Thank you, counselor. Plaintiff, you may proceed.
Dr. Elmore, if we could just get Exhibit 2 back up on the screen.
Sure, might take a moment.
That's all right.
Long presentation here. All right, there we go. There we go.
All right, could you focus in on that chart? All right, I want to focus on the initiates quickly. How much do they make up of the company using this chart?
They make up 63% of the company.
And ma'am, on average, how much are they earning for the company?
Only about $223.
All right, I want to compare that to the people who do get promoted for recruitment. Let's look at the ambassadors. Ma'am, how much of the ambassadors do they make up?
They're going to make up only about 3% of the company.
And how much money is this 3% making?
The people who have been promoted the most for recruitment, they're going to be making $34,000 a year.
Does any other level make more money than them?
No.
Thank you for that visual. So, Dr. Elmore, we talked about the structure of a pyramid scheme and Warhater's business structure. What conclusion did you reach in your expert opinion?
Well, after looking into Warhater Energy Drink's recruitment model and then seeing how money aggregates at the top of the recruitment ladder, I believe that this company has the hallmarks of a pyramid scheme.
Thank you, Dr. Elmore. Your Honor, I have no further questions.
Thank you, counselor. And you may proceed with your next witness, plaintiffs.
Sorry to pause for 3 seconds. Congresswoman Crockett, I just messaged you. If you could just see that real quick, and then continue whenever you're ready.
Okay, I am ready.
Your Honor, may the defense proceed with cross-examination?
Yes. Sorry. Go ahead.
Good evening, Dr. Elmore. How you doing tonight?
I'm good. How are you?
Doing well, thank you. I want to pick up right where you left off on direct examination. Let's talk about whether this company has the characteristics of a pyramid scheme.
All right, happy to.
You'd agree classic pyramid schemes only do recruitment.
That's right. Traditionally, pyramid schemes are really only concerned with recruitment. They can have products. It's a little bit of a, I guess, not a clean distinction.
Okay, doctor, but classic pyramid schemes don't sell a product. This company does sell a product.
That's right. They have energy drinks.
Classic pyramid schemes also force their sellers to buy inventory.
Yes, that's how the people above those bottom level sellers make money.
Right, doctor. But this company doesn't do that.
No, but to receive bonuses, you do need to be an active seller, which is a $3,000 monthly payment.
I understand that, doctor, but directing you back to my question, they don't force people to buy inventory, do they?
No.
Doctor, what actually makes a company a pyramid scheme is if more money comes from recruitment than sales.
That's right.
Let's talk about whether you answered that question in today's case. Doctor, you didn't actually talk to anyone from this company.
No, that's not my job. I was just asked to look at the structure. So I looked at affidavits of sellers, the CEO, and the CFO. I didn't go conduct interviews or anything like that.
Sure, doctor, but I'm not asking about statements. I'm asking about one-on-one interactions. And you didn't conduct any interviews in today's case.
No.
Didn't talk to any executives.
Directly, no.
Didn't talk to any sellers.
No.
You didn't ask them if they made more money from recruitment or sales.
No, I looked at their affidavits and analyzed those.
Doctor, you didn't even speak to your own client.
The attorneys? I spoke to the attorneys.
The plaintiff in today's case, you never sat her down for an interview, did you?
No.
Doctor, let's talk about what you did look at in today's case. You actually only looked at one financial document from this company.
From the company or from the sellers?
Doctor, in your entire investigation, you only looked at one financial document. Exhibit 2.
That's not true, sir. There was more financial documents.
Doctor, from the company, you didn't look at any pay stubs?
No pay stubs.
No commission reports?
That's right. I wasn't running an audit. I was looking at the structure of the company.
Okay, so let's break down Exhibit 2. Ms. Mendez, or Your Honor, if we could permission to display that now, it's already in evidence.
Permission granted.
Yes, Your Honor. And thank you, Ms. Mendez. All right, doctor. Now you're telling us that the reason the people at the top make more money than the people at the bottom is because of recruitment?
That's right. They're going to have the most number of recruits underneath them, and so they're going to be receiving the most amount of bonuses from that monthly product purchase.
Wait, hold on, doctor. Stay with me. This company, or this document, it says how much the people made, right?
It has average annual earnings. You're right.
Right. It doesn't break down where the money comes from.
That's right. I actually don't believe there's any evidence that the company itself attracts things like that.
Doctor, let's take a look at the numbers. You mentioned 34,000 on direct examination, correct?
That's right.
Doctor, that's how much the average ambassador makes.
You're right, sir.
This document doesn't break down what percentage comes from recruitment.
That's right.
It doesn't break down what percentage comes from sales.
It does not.
Doctor, you can't tell us what percentage comes from recruitment, can you?
I'm sure there's an average I could get going about that, but I right now, no.
But the bottom line is it's not in the document, is it?
No.
Doctor, did you consider any other reasons why the people at the top make more money than the people at the bottom?
I did.
Doctor, it's true that the ambassadors worked at the company for 3 years, right?
That's right. Ambassadors tended to be with the company longer, and they have more recruits.
The initiates, they don't even have a number?
That's right. Warhater Energy didn't give any number for the tenure of initiates.
So to be clear, the people who have worked at the company for longer make a lot more money than the people who just joined.
Well, we don't really have a number there, but that's right. Ambassadors make more money than initiates.
Right, doctor. So directing you back to my question, the ambassadors who worked at the company for a lot longer make more money than the initiates who just joined.
That's right.
Thank you, doctor. I have no further questions, Your Honor.
Any redirect?
No redirect, Your Honor, if Dr. Elmore could be excused.
Absolutely, you are excused.
Thank
Any
you.
objections? Well, let me ask, defense counsel, do you have any objections to excusing this witness?
Sorry, Your Honor. No objections at all. We've taken enough of Dr. Elmore's time tonight.
Thank you so much, counsel. Plaintiff's counsel, you may proceed with your third witness.
Yes, Your Honor. Plaintiff calls Chris Rone to the stand. Proceed when ready.
Yes, you may proceed.
Thank you, Your Honor. Good evening. Could you introduce yourself to the members of the jury?
Hi, my name is Chrysanthemum Rone, but the PTA moms have an easier time saying Chris, and it's stuck.
What do you do for a living?
Well, when I'm not quilting little things, I'm knitting up digital content. So YouTube, Instagram, TikTok, all that jazz.
What brings you to court today?
Well, I collaborated with the folks at War Hater Energy a little while back, and so with this whole lawsuit business, I've come in to say a few words.
How did you start off with War Hater?
Yeah, so it all started when I got a DM from one of the ambassadors. They sent me a bunch of darling trinkets and drinks, of course, to sell, and so I just jumped right in.
How did you try to sell it?
Well, I shared all about it on my social media pages, of course, at Sewing with Rone.
And how did selling go for you, ma'am?
Well, not too great. After a couple weeks, I'd sold everything, but I only made about $180 total.
$180? Was that all right with you?
Oh, no, goodness, no. My carpal tunnel started flaring up, and for so little compensation. So I demanded that the folks at War Hater let me speak to someone who's in charge.
Ma'am, were you able to secure a meeting with the higher-ups at War Hater?
Sweetie, does a one-legged duck swim in circles? You betcha I got myself onto a meeting. Well, okay, I snuck onto a meeting.
Where was that meeting, ma'am?
Oh, it was on Zoom. Hopped onto a little Zoom link.
Who was at that meeting?
I remember there was someone there named Reese Nocti.
Do you know who Reese Nocti is?
Oh, of course. Yeah, that's the CEO of War Hater. Her name's on my welcome letter.
I want to talk about what the CEO admitted about her business. Did the CEO talk about people who weren't selling their inventory?
Yeah, she said that the money in War Hater, well, it came from having a team of people underneath ya.
Thank you, ma'am. Nothing further.
Cross-examination, Your Honor?
You may proceed.
Yes, Your Honor. Good evening, Miss Rone. Geez, it's getting real late, ma'am.
Oh, isn't it? Good evening.
Ma'am, I'm just going to ask you a few questions. And I actually want to start by talking about why you might be testifying today. Now,
Okay, shoot.
ma'am, you work as an influencer, right?
Oh, I don't know about it. Yeah, I love to make content.
Right, ma'am. And making content, that's one of the primary ways that you earn money, right?
Oh, sure. Yeah, you betcha.
But back in 2021, well, you weren't very successful in your influencer role, right?
Oh, I was making my videos. I was happy with the attention they were getting.
Ma'am, you only had around 500 followers or so?
Oh, yeah, my original 500. Yeah, my roommates.
Right, ma'am. But that number, well, it began to change, right?
Wait, did?
Because after you stopped working for Worry Hater, you started trashing them on your social media platforms, right?
Okay, I'm gonna let you in on something. I started calling them a bunch of no good Nancy's. I don't want the kids to hear. That's what I mean. Anyway, yeah, and after that, we got some followers. I think we got up to the population of Circle Pines, Minnesota, is where I'm from, about 5,000.
Right, ma'am. As you started to trash Worry Hater on your social media platforms, your follower account began to increase, right?
Yeah, up to about the population of Circle Pines. I tell you, I was happy.
That's a yes to my question, ma'am. Your follower account count began to increase.
Yeah.
But ma'am, you're actually okay with profiting off of Worry Hater, right?
Oh, I'm not sure what you mean.
Well, ma'am, you actually think that Worry Hater's karma is coming, right?
Oh, yeah, okay. There was this song going around. My kids are really on the internet. Don't know where they get it from. But yeah, there was this song going around. Must have been in my head, because yeah, I guess I said something about karma.
That's a yes to my question, ma'am. You think Worry Hater's karma is coming.
Yeah.
And ma'am, you actually think that what's bad press for Worry Hater, that's good press for you, right?
Who would have known? Yeah.
So ma'am, you're here today and you're trying to make, well, more bad press for Worry Hater and more good press for you.
Oh, yeah, I'm just trying to tell my little story.
Well, ma'am, you testified earlier that you didn't make a lot of money selling with Worry Hater, right?
Oh, no. And I even made a little quilt. Do you want to see it?
I'm okay, ma'am. Thank you. But ma'am, you're telling everyone on this Zoom that you didn't make a lot of money, right?
No, not much.
And ma'am, if you look in that sort of right-hand corner of your Zoom, you're telling everyone on the live stream that as well.
Yeah, I.
So then let's talk about if we can trust the story that you're telling us today. Because you told us that you got onto some sort of secret Zoom call with the CEO of Worry Hater. Did I hear that right?
You betcha.
Let's be real clear, ma'am. You can't show us the Zoom link that you used to get on that call, right?
No, I think I'd have to go back into my search history. They're not going to ask about my search history, are they?
No, ma'am. I'm just going to ask about what you can show us today in court. You can't show us a picture of that Zoom link.
No.
You can't show us a screenshot of the email you got with that Zoom link.
Oh, goodness, no.
You can't show us maybe a Google Calendar invite that says secret Zoom meeting in 10 minutes, gotta go.
Oh, no.
Ma'am, you don't have a single piece of evidence in court with you today that shows that this Zoom call ever happened.
I guess not, no.
Thanks, ma'am. Thank you, Your Honor. No further questions.
Any redirect?
No redirect, Your Honor. We just ask that Ms. Rone be excused.
Any objection to this witness being excused?
No objection, Your Honor.
All right. Plaintiff's counsel, do you have any other witnesses?
No, Your Honor. With that, plaintiff rests our case in chief. This time, we just ask for a 5-minute recess, all loss permitting, before we move into defense case in chief.
Any objection to a 5-minute recess defense?
No objection, Your Honor.
All right, 5 minutes.
Hi, Your Honor. Just wanted to let you know that the defense is back and ready to proceed.
Thank you so much, Counselor. Plaintiff's counsel, are you back and ready as well?
Yes, Your Honor, we're back.
Okay. Well, let's get round two going.
Yes, Your Honor. At this time, the defense calls Vade Vasudan to the stand.
All right, please proceed.
Good evening, sir. Please introduce yourself to the members of the jury.
Good evening, everyone. My name's Vade Vasudan.
What do you do for a living, sir?
Well, currently I'm a private financial consultant for the firm Farnsworth Fritch LLC. Basically, I advise people approaching retirement age on how to maintain comfort and a good lifestyle, even as they stop working.
Have you always done that?
No, not at all. I actually used to be the senior investigator for the State Trade Commission. Worked there for around 2 decades.
Tell us what an investigator for the State Trade Commission does.
Trade Commission investigators are sort of like detectives, except instead of looking into people and crimes, we look into businesses and fraud.
I understand, sir. Why don't you do that anymore?
Unfortunately, a couple of years ago, someone on my team leaked confidential information to the press. I was horrified. Private information has to stay private. I took full responsibility for what happened, and the commission and I decided I would step back.
Okay, sir. Well, today I want to talk to you about a different investigation. Have you ever investigated a company called Vade Energy?
Yes, I audited their business back in 2020 after we received an anonymous complaint against them.
How did you go about that audit?
Well, I just followed standard Trade Commission protocol. I looked at their numbers, their financial information, their marketing. I even spoke with the CEO of the company just to make sure no stone was left unturned.
Is that a reliable method, sir?
Certainly. I've used it in nearly 150 investigations, and I've testified to this technique 40 times in court.
Did you have all the materials you needed to complete your investigation?
Sure. I had access to all the documents I just mentioned.
And I have to ask, sir, did you reliably apply your method to those materials?
I always do.
All right, now that we've gotten that out of the way, tell us what was the result of your investigation.
Well, after a probe of Vade, I determined that there were no violations of Trade Commission policy.
All right, sir, I want to take this from the beginning. What were you looking for when you investigated this company?
I was looking for whether the company was exhibiting symptoms of what we call deceptive trade practices.
What is a deceptive trade practice?
Well, unfortunately, there's no one-size-fits-all. They take many different forms. I actually brought along a couple examples. Can we pull those up, Mr. Ackerman?
Sure thing, sir. Your Honor, permission to display a demonstrative aid?
Permission granted.
Sir, all I see is a blank screen. What are we looking at here?
All right, well, I wanted to show you a couple examples of potentially deceptive businesses. The first one right here, this is one that you might unfortunately be familiar with. It's a common web scam where the scammer says that you can get a big gift card or maybe some cash if you provide your username, your password, maybe your mother's maiden name. It's a classic example of small-scale fraud.
All right, then what's an example of large-scale fraud?
Mr. Ackerman, you ever heard of something called FTX? Anyway, that's a cryptocurrency exchange that collapsed a couple of years ago. This is one of the actual tweets they sent out publicly. They were trying to get investors to have people sign up, and they claimed they would give you a cash payout if you joined. It's a billion-dollar business built on deception.
Sir, what do these examples have in common?
Well, they both involve deceit. A person or a company trying to mislead you into paying them money. That's bad, obviously. We want companies to be upfront and forthcoming with the people they deal with.
For the record, the demonstrative's no longer being displayed. Now, sir, let's talk about whether this company was upfront. What did you find?
Well, maybe it'll be helpful. Mr. Ackerman, can we pull up those disclosures I mentioned to you earlier? Maybe that could help explain.
Sure. Your Honor, permission to display Exhibit 2, it's already in evidence.
Permission granted.
Sir, tell us what we're looking at.
All right, this is a financial disclosure of WarriHater that I reviewed in my investigation. I cut out some of the important bits to try to show you all.
Okay, what stood out to you?
Well, if you take a look at the bottom here, they disclose risks about the company. They say there are no guarantees regarding earnings, and the success or failure of each WarriHater seller, like any other business, depends on many factors, including your own skills and personal effort.
Sir, why did it matter to your investigation that they disclosed this about the company?
Well, it was important to see that they were upfront with the risks that people took on by buying inventory and reselling it.
All right, did they disclose information about the details of the job?
Oh, sure. They gave a job description at the top of this document. They say, you're here to sell energy drinks. And then they also say that the primary income should be derived from product sales.
And why did these statements matter to your investigation?
Well, it's important that companies give an accurate description of the job. It would be deceptive if, I don't know, you had a job posting for a librarian, and then when she got there, you forced her to do manual labor or something. In this case, they were forthcoming with the job description.
Were they forthcoming about what sellers might receive from the company?
Sure, let's take a look. It says a typical WarriHater seller in the United States earned just $172.
Okay, what did all these disclosures mean to your investigation?
Well, it meant that they were forthcoming about the job description, about the average earnings of sellers, and about the apparent risks in the business.
Thank you, Ms. Mendez. We can take that down now. Now, sir, after you reviewed this document, what'd you do next?
Well, after seeing these disclosures, I decided to start wrapping up the investigation. But just to be safe, I left the case file open on what we call monitored status for 6 months. That basically means any member of the public, employee, seller, can complain to the State Trade Commission, and we'll see it.
Did you receive any other complaints?
No. In those 6 months, we got no more complaints about the Trade Commission. That's when we officially closed the case and issued no citations.
Thank you for your time, Mr. Vasudan. Nothing further, Your Honor.
Thank you so much. Cross-examination.
Yes, Your Honor.
You may proceed.
Good evening, Mr. Vasudan.
Good evening, Ms. Tang. How are you?
I'm doing great. How are you?
Not bad. Sort of just been on Zoom calls all day, kind of tired.
I'm in a similar position to you, sir. Now, I want to start our conversation by walking through the steps that you took during your audit, okay?
Sure.
Now, you said you started your investigation by looking up the company's public website, right?
That's correct. That was the first thing I did after we got the complaint.
Right. You opened your computer, just like this one, and you clicked through some of the pages.
Yes.
And while you were looking through the website, you found messages from WarriHater Energy telling people to join the movement, right?
Yes.
This was concerning to you.
Concerning how?
Well, sir, you were concerned that there were so many messages telling people to join the movement.
Sure, I did have some level of concern, but I was not concerned this was a pyramid scheme. Any focus on recruitment, a heavy focus on recruitment, doesn't always indicate that. If so, colleges would be in big trouble.
Well, sir, I don't want to just brush past this, because you were so concerned about that you went ahead and emailed the CEO of the company. True?
Yes.
And after that, you had one conversation with them?
Correct. I did an interview.
No more interviews after that?
No, just one.
So after just one look at the website and one conversation with the CEO of the company you were tasked with investigating, You wrapped up your investigation.
Not quite, no.
Is it your testimony that after you looked at the website and talked to the CEO, you didn't wrap up your investigation?
Well, I reviewed a couple other documents. I reviewed that disclosure document and then another informational guide.
Well, hold on, you just mentioned that you reviewed financial documents. I want to make something clear. You reviewed 2 pieces of paper, true?
Correct.
2 single-sided pieces of paper.
That's right.
All right, so it's true that after one look at the website and one chat with the CEO, and then a look at 2 pieces of paper, you wrapped up your investigation.
Sure. That's when we put it on that 6-month monitored status period.
All right, now I noticed you mentioned this 6-month monitored status period. I want to talk about what you actually did during that period. Now you're saying you kept it open, right?
I'm so sorry. Could you repeat that, ma'am?
You kept the investigation open. Is that what you said?
Yes.
Now, in those 6 months, you never spoke to anybody else at the company except for the CEO, right?
Yes.
You never spoke to any of the employees at the company?
No.
So you wouldn't have happened to have spoken to Marty Jones, right?
No, certainly not.
You never spoke to a Chris Rone?
No, that's not part of the technique, unfortunately.
You're saying it's not part of the technique. Well, because you didn't speak to any employees at the company, you don't know if any of them had complaints about the company's business structure.
Well, we would have received complaints because of that monitored status. We can see the complaints that they submit to us.
Well, sir, I'm not asking if you received complaints. Is that you didn't look for any because you didn't talk to any of the employees at the company?
That's right. I didn't speak with them.
You also didn't speak to any other executives at the company?
No.
So you weren't able to corroborate or confirm any of the information about the business model that the CEO told you about?
Well, I was, because I also looked at the websites and the documents.
But sir, just to be clear, you took one look at the website, which is public information, and you looked at 2 pieces of paper.
Absolutely, you're right.
Now, I have a question for you, Mr. Ruben. Do you trust the company?
Sure.
Well, I want to talk about whether or not the company trusted you, whether or not they were upfront with you. Because you'd agree that it would be a problem for the defendant if they were hiding information from you, an investigator at the Midlands Trade Commission.
I agree.
Now, in your one conversation that you had with the CEO of the company, they never told you that employees were losing tens of thousands of dollars while working there, right?
Objection, Your Honor. Attorney testifying to facts not in evidence. May I be heard?
Proceed.
Your Honor, nowhere is it on the record that multiple employees of this company are losing tens of thousands of dollars.
Plaintiff's counsel. Response.
Yes, Your Honor. This information is included in the affidavit of the CEO. While we understand that the CEO is not being called today, their statements are not hearsay because they're statements made by a party opponent.
Response.
Please.
Your Honor, we're not objecting that they're hearsay. We're objecting that they're not on the record. An attorney is testifying.
The attorney asked the question, but I guess because it is cross-examination, stated it. So what I am going to do is I am going to sustain the objection, but give plaintiff's counsel an opportunity to reform your question.
Yes, Your Honor.
Go ahead.
Sorry, I'm so sorry.
No, go ahead.
Oh, Your Honor, at this time, permission to read statements from the CEO's affidavit onto the record?
Any objections?
Yes. Yes, Your Honor, that's not an evidence. Just because it's a statement from the CEO doesn't mean it's admissible. If they wanted these statements in evidence, they should have called the CEO to the stand and issued a subpoena.
Defense counsel is right. You may want to reform your question, plaintiff's counsel. In my opinion, you can probably get to where you're trying to go. I'm guessing. But you may want to restate your question.
Yes, Your Honor. Now,
So that last objection is sustained to where we won't allow that statement to be admitted into evidence. But I do understand that it is a part of the packet. So proceed with your question, and hopefully you can get the information you're seeking.
Yes, Your Honor. All right, well, Mr. Ruben, continuing our conversation, you're not aware of any employees that were losing tens of thousands of dollars at your company or at the company?
No, I didn't find evidence of that.
Would it surprise you if there was evidence about that?
If there was evidence about, I'm sorry.
About employees losing tens of thousands of dollars at the company?
I don't know if I'd say it would surprise me, no.
Well, sir, you were never told any information about employees losing money, right?
Not specifically.
This is the first time that you've ever heard that employees might have been losing money at the company?
Not quite. The CEO did tell me that there were some people who weren't making much money.
Objection, Your Honor. If I may be heard.
Go ahead.
I re-raise my previous objection that attorney is testifying that referring to facts not in evidence. It's not even on the record that a lot of people in this company are losing money. The plaintiff's expert didn't even say that.
I think the timeliness of this particular objection, it may have gotten past you. So I am going to overrule that. Was there any other objection that you had?
Not at this time, Your Honor. I'll try to be on time next time.
You got to be on time. Go ahead, plaintiff.
All right, Mr. Vasudan. I'm going to need a yes or a no here. In the past 4 years, you have never conducted a full investigation on Warhater Energy, yes or no?
No, beyond the review I did, no.
Thank you so much for your time. No further questions.
Redirect, Your Honor.
Please proceed.
Hi again, Mr. Vasudan.
Hello.
Now, opposing counsel asked you a bunch of questions about people you didn't talk to in this company. Do you remember that?
I do.
Sir, did you need to talk to any of those people to determine whether Warhater was being upfront with their sellers?
No, I wasn't. Based off the evidence I reviewed, I was able to close the case.
Thank you, sir. Nothing further.
All right, defense counsel, please call your next witness.
Yes, Your Honor. At this time, we call Dylan Starr to the stand.
You may proceed.
Yes, Your Honor. Good evening. Could you please introduce yourself to the members of the jury? Oh, I introduce myself? Okay. Give me a sec. Yeah, I'm Dylan Starr. I'm a Virgo. My favorite color is leopard print. Is that good? Is that enough? That's perfect, ma'am. Could you tell us what you do for a living? Well, I'm a full-time babysitter. Some might say mother. It's unpaid. But I also work as a saleswoman for an energy drink company, Warhater, on the side. How'd you become a saleswoman? You know, don't get me wrong. I love my kids very much. I love my husband enough, but I needed an opportunity to do something for myself. You know, feminism. So when I found out in 2020 I could work for him part-time, well, I decided to join in. Well, I want to talk about if Warhater was upfront with its sellers. What was the first step to becoming one? You know, before the ball gets rolling, they send you this care package. Has your little welcome letter, some money, stuff, that sort of thing. Your Honor, permission to screen share Exhibit 2. It's already in evidence.
Permission granted.
Ma'am, is this that document you were sent? Oh, yeah, that's it up there. Ma'am, what did it tell you? Well, I read about how the business works, what to expect, and what they expected from me. Well, I want to break that down. What was the focus of the job?
I mean, you're there to sell. That's what we were told. Oh, yeah, wait, right there. Don't move it. That's it right there. Yeah, yeah. Yeah, literally the first sentence there. You're there to sell energy drinks. Mm-hmm.
Well, ma'am, where was most of your income supposed to come from?
It says product sales.
Did Warhader guarantee you any type of earnings?
You fancy. No. They told you that there were no guarantees regarding earnings, that success or failure depends on how skilled you are, how much effort you put in, and I believe how high you tease your hair.
Well, ma'am, in your personal experience, did you find this to be true?
Yeah, as someone who likes to keep tabs on the new sellers, I got to see how people could sell when I saw them work hard.
Well, then, ma'am, I want to talk about if someone can make money at Warhader when they put in that work and effort. After reading those disclosures, how did you try to make money?
It didn't take much. I sold to my neighbors, I sold to my friends, sold to ladies at my yoga class, those PTA moms? Yeah, I got them in on it.
Anything else?
Geez, okay, you want more? Let me think. Yeah, I would make promotional posts on Facebook. Surprise, surprise, my main clientele, recently divorced mothers. The Ozempic, it makes them tired.
Well, Miss Starr, after doing all this, did you make money at Warhader?
Of course. I mean, I sold out my first week alone, profited $2,000 selling those drinks my first month.
Well, ma'am, after you profited $2K from sales alone in a month, during that time, how much were you actually working?
Not a lot. I was only working part-time, but I gave it the old college try. I imagine that's something they teach in college. I didn't go, so I wouldn't know. Sorry. Jimmy Jr., if you don't go back to your room right now, stop biting your brother. Go. Okay, I'm sorry, ma'am. Where were we?
Completely understand, no worries. How much did you make in a year working part-time for Warhader?
A year, yeah. I kept selling, got a little coin from recruitment, some speaking gigs. Overall, I made $75,000.
Well, I want to talk about if other sellers were making money too. Now, you mentioned you kept tabs on new sellers. Did they ever tell you they were losing tens of thousands of dollars?
No, goodness, no. No, I don't know how you could lose that much money.
What do you mean?
There are speaking events, stories you can hear, lots of support on the website. I mean, if you have questions, you can even find a photo of yours truly up there. Full regalia.
Well, ma'am, did you ever see a woman named Marty Jones at any trainings or sales events for Warhader?
Marty Jones? No, I didn't.
Thank you, ma'am. No further questions at this time.
Cross,
Yes, Your Honor.
you may proceed.
Good evening, Miss Starr.
Hi there.
Mr. I want to start by talking about a couple of things you mentioned on direct examination. Ma'am, you were telling us on direct that you sold the Warhader products, right?
Mm-hmm. Yeah, sold all those cans of the energy drink.
You said on direct that you made $2,000, right?
Yeah, in 1 month.
I noticed your attorney, she didn't ask you what you started doing after that first month, right?
What do you mean, sorry, start doing?
Well, Ms. Starr, after that first month of selling, you started recruiting.
Yeah, mm-hmm.
And in just your first week of recruiting, ma'am, you made $1,500, right?
I signed up a couple people, the ladies at my yoga studio. It's a Tony's Pizzeria on Route 22. They all wanted to sign up to sell.
Ms. Starr, you just said you only signed up a couple of people and that was enough to make $1,500?
Yeah, it was a few, 5, 6, somewhere around there. Yeah, I don't remember.
So, ma'am, in just 1 week of recruitment, you made almost as much as you did in your first month of selling.
Let me think about the math. 2K, 1,500, yeah, like 500 difference, sure.
All right, so ma'am, I want to talk about what the structure of the company might allow you to do. Now, ma'am, you were asked on direct how much you made part-time working for Warhater, right?
Yeah, 75K. Don't tell my husband.
So, ma'am, right now you made that 75K, but you're also an ambassador for the company, right?
An ambassador. I know it doesn't roll off the tongue, but I'm proud of myself for that one.
So, ma'am, being in this status, that means you've recruited 40 people, right?
Yeah.
So let's just say all 40 people that you've recruited are active members, okay?
Okay.
Ma'am, if all 40 people are active members, you can make $12,000 in just 1 month of recruitment.
Objection, Your Honor. Improper lay opinion. May I be heard?
Sure.
Yes, Your Honor. Opposing counsel is asking this witness a hypothetical question about what she would earn if people in the company were recruiting or buying certain things. Well, she would need to have expert foundation under 702 to testify as to a hypothetical question.
Plaintiff's counsel, do you want to respond?
Yes, Your Honor. Your Honor, this doesn't need expert foundation for Ms. Starr to testify about her own structure and how she understands the company that she's working at works. Also, they opened this door on direct examination when they started asking Ms. Starr about what the structure of the company does.
I'm going to overrule it.
Yes,
she can
Your Honor.
testify as it relates to her own experiences, and I think that the foundation has been laid that she has a certain number of recruits under her, and I would anticipate she knows how much money she's supposed to get based upon that. So I will allow you to proceed, plaintiff's counsel.
Yes, Your Honor.
So, Ms. Starr, with 40 active members, you would make $12,000 in just a month because of recruitment.
No, ma'am, I'm not sure. My favorite class was when we had a substitute teacher and we watched movies, but I'm gonna take your word for the math.
So, Ms. Starr, in 1 year, that's $144,000 just from recruitment.
Sure, that sounds right. Maybe, yeah.
So, Ms. Starr, how many cans would you need to sell to earn $144,000 in a year?
I'm not sure. Sorry, I can't do the math.
That's all right. So, I want to talk about whether or not the company was actually upfront about how to make money. Now, Ms. Starr, on direct examination, you talked a lot about these events, right?
Yeah.
You know, you even said that you didn't see Marty Jones at these events.
Yeah, that's true.
So I want to talk about what kind of events these actually were. Because, Ms. Starr, they weren't sales events, were they?
They were events to get to talk about Warhead as a company, yeah. You know, I got to share my success story. How I went from being a full-time mother to having an excuse to get dressed and go out of the house.
Ma'am, these events, it wasn't just to talk about your success story. These were recruiting events, right?
Yeah.
Ma'am, the executives of the company, they sent you to these events.
I know.
These executives, they sent you to these events so that you could recruit people into the company.
Yeah, share my story and do that.
Ma'am, the executives, they told you that your job was to sell people the idea of being recruited.
Yeah, I gave him the dream of joining the company. A dream came true, though I'm still waiting for my Prince Charming.
Now, Ms. Starr, it's also your belief, ma'am, that recruitment's where you make a lot of money.
Yeah, you know, definitely some. I'm putting mine aside so it can help me get my tubes tied for Mother's Day.
Ms. Starr, I noticed you said some, but in your own words, you make a lot of money through recruitment.
Yeah.
Can I take that as a yes?
Yeah, sorry. Yeah, yes.
Thank you, Ms. Starr. Your Honor, I have no further questions.
Thank you. Is there any redirect from the defense?
No redirect, Your Honor. We just ask that she be excused.
Is there any objection to this witness being excused?
No objections, Your Honor.
All right, you are excused, Ms. Starr. And defense, please call your next witness.
Yes, Your Honor. At this time, the defense calls Aaron Ruben to the witness stand. May I proceed?
You may proceed.
Yes. Good evening, where I'm at. Miss Ruben, I know it's been a long day.
Yes, certainly has.
Miss Ruben, could you introduce yourself to the members of the jury?
Sure. Hi, my name is Erin Ruben.
What do you do for a living, ma'am?
I'm the CFO and co-founder of Worry Hater.
Have you always worked for Worry Hater?
No, I actually used to be the CFO of a company called DigiMoney. We focused on complex, high-volume, cross-border digital transactions. Super boring stuff, but successful company.
So why'd you end up leaving DigiMoney?
Well, it was a solid learning experience for sure, but it was too corporate for my taste. I wanted to try something new. I don't know if you have kids, but when you do, you'll see how much your priorities change.
So how exactly did you find Worry Hater then?
How'd I find Worry Hater? It found me, really. I met our CEO at, God, I don't even remember where, but we started talking and she was just brilliant. And she told me about her idea for an energy drink that used all natural ingredients, and she asked me if I was interested.
Were you? Did you take her up on her offer?
Yes, I was excited about joining something new. And when she offered me a bring your daughter to work day, couldn't say no.
All right. Well, Miss Ruben, we've talked a little bit about you. I'd like to talk more about Worry Hater. Now, can you tell me a little bit more about how exactly Worry Hater is set up?
Sure. It's pretty simple. We have sellers who buy the energy drinks from us at discounted prices. They sell them, and they get to keep the profits.
Now, why do you do that as opposed to just putting those drinks in, say, chain stores?
We think it's the best way to get our consumers the best product at the best prices. It also helps us build a loyal network of sellers who want to sell our energy drinks.
Well, do you know if this strategy is popular with sellers?
Sure is. Not shortly after we started, we had a waiting list of people who wanted to sell Worry Hater. I mean, it's still growing. Which is why we do everything in our power to protect our sellers.
Ma'am, how exactly does Worry Hater protect its sellers?
We do many things, but I can think of two in particular. We're upfront and we protect our sellers.
All right. Well, then let's start with that first one, that you're upfront. Now, what exactly does upfront mean in the context of Worry Hater?
Sure. It just means we tell our sellers about every aspect of our business, which in practice just means we provide them with disclosures before they start selling.
What sort of disclosures?
We have a financial disclosure packet. It's pretty clear on our mission.
What's that mission, ma'am?
To sell. Being a Worry Hater contractor means selling our product, and that's exactly what we tell our sellers.
Ma'am, why does Worry Hater feel the need to be upfront about selling?
Because the business of sales, it's risky. Being a salesperson, it's almost like managing your own business.
How so?
Well, at Worry Hater, sellers are essentially independent contractors. They decide when, where, how they want to sell. I mean, it's all up to them.
And what about that is risky?
Well, like I said, sales, it can be unpredictable at times, and there are ultimately just no guarantees. That's why we want our sellers to know the risks before they join us.
So does Worry Hater help sellers navigate those risks?
Of course. Of course. We lay out clearly in our disclosures that you need to put in effort and work, and even then, sales just are not a guarantee. No matter how much we might want to, we can't make any promises about success.
All right. Well, we've talked a little bit about how Worry Hater tries to be upfront. I'd like to talk about that other thing you mentioned, protecting sellers. What does that mean to Worry Hater?
Sure. It's just not in our values to turn our backs on any of our sellers, regardless of their level of success.
Do you have any specific protections for them?
We have a refund program, which acts as a safety net for sellers who realize that, sales just isn't their thing. We give them the opportunity to get their money back.
Ma'am, with all of the work that you've done for Worry Hater sellers, what's your response to the accusation that your company engaged in deceptive practices?
It troubles me to think that anyone would think that. I built our finances from the ground up. It was the most important thing to me that we were upfront and honest at all times.
Ma'am, did you ever create intentionally misleading marketing materials?
No, absolutely not.
Did Worry Hater ever force sellers to buy product?
No, never.
Ma'am, did Worry Hater ever try and take advantage of sellers in any way?
No. Look, Miss Jones, I don't know if you're still listening in, but I'm truly sorry if you feel like you've been taken advantage of. That's not what I stand for, and it's certainly not what Worry Hater stands for.
Thank you, Miss Ruben. Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor.
You may proceed.
Evening, Ms. Ruben.
Good evening.
I want to start by picking up where you left off with that refund process, all right?
Okay.
Now, you'd agree with me that refund process, well, it's flawed.
That's right. Small business, still trying to work out some kinks.
You'd say you have some quality control issues?
That's true, yes.
You'd say your refund process, well, it's not working optimally right now.
No, it's not optimal, but still functional.
You're saying it's still functional, but ma'am, it's not even fully staffed, is it?
No, not yet.
You're not aware of any hiring efforts to try to get it fully staffed?
No, but I know that's the long-term goal.
Ma'am, these issues with your recruitment model, those aren't in any of your financial disclosures, are they?
I'm sorry, issues with the recruitment model? I'm not sure what you mean.
Ma'am, you're not disclosing to your sellers that your refund model is understaffed.
No, because the refund system works. People who want a refund should be able to get one.
Ma'am, that wasn't quite my question. You're not disclosing to your sellers that your refund system isn't working optimally.
No.
All right. So I want to talk about if you're testifying to save your job. Ma'am, you've got 2 degrees in finance, correct?
That's right. Very, very hard-fought degrees.
After that, you became a chief financial officer.
Yes, that was the role at Digimoney.
That's right, your last firm was with Digimoney.
Yes.
You made their business plan.
That's right.
Then you came to Worry Hater.
Yes.
You also made Worry Hater's business plan.
That's also correct.
Ma'am, if Worry Hater loses their case today, that's an indictment of your business plan, correct?
Objection, Your Honor, calls for speculation on behalf of the witness.
Response.
Your Honor, there's no speculation required. It's already been laid on the record that this witness made the business plan. If the business plan's indicted, that's her business plan. No mindset for her to step into.
Response, Your Honor.
Please.
Your Honor, it forces this witness to speculate either way. If she says yes, she's speculating as to whether or not this indictment is directly an indictment of her business plan. If she says no, then she's saying no, it's not an indictment of her business plan. She can't testify to whether or not the jury is indicting this charge specifically because of the business plan or because of other factors.
That's really what I thought was going on. Plaintiff's counsel, restate your question, because that's
course,
not
ma'am.
what I got out of it.
The question was if War-A-Hater loses its case, that's an indictment of your business model. We were all here for opening statements. We heard the business models, what's on trial. I deliberately began my question with if, so that we wouldn't have to have her speculating into a yes, yes, she's found liable. No, she's not found liable.
I think at this point, I'm going to overrule the objection.
Yes, Your Honor.
You may proceed.
Ms. Ruben, you'd agree that if War-A-Hater loses its case, well, that's an indictment of your business model.
I'm not sure. I mean, I made the business model, if that's what you're asking, yes.
Because, ma'am, you can't just make any business plan you want, can you?
I'm not sure what you mean, no.
You're not sure what I mean, ma'am. That business practice has to be legal.
Of course.
So you came in today, you testified for us on direct examination. I want to talk about the truth about War-A-Hater, because the truth is a lot of your sellers aren't making very much money.
That's true. A lot of our sellers aren't making much money, but a lot of them are. That's right.
Well, in your company, you've got a tiered business structure that separates your sellers.
That's correct.
There's 4 tiers of employees.
Yes.
This is all outlined in your financial disclosure.
That's right.
You'd recognize if I showed it to you.
Of course, I made it myself.
Your Honor, plaintiff is showing Exhibit 2. It's already in evidence.
You may proceed.
Ma'am, this is your company's business model.
Yes, these are our financial disclosures.
The lowest, if we could, Ms. Lay, move forward in the slideshow. Thank you. The lowest level of your company, the initiates, all the way in the top left, they make on average $223 annually. That's correct?
That's correct.
And all the way on the bottom, the ambassadors, the highest level of your company, they make $34,000 annually. Isn't that true?
That is also true, yes.
Thank you. You can take that down now. So let's talk about if the difference is selling or if it comes from recruitment. Ma'am, everyone in your company is selling the same energy drinks, aren't they?
That's true, yes.
Everyone in your company is selling them for standardized prices.
Yes.
On the other hand, everyone in your company makes a bonus from recruits.
Yes, if they so choose.
But not everyone makes the same bonus from recruitment.
I mean, yes and no. We do have a flat fee for recruitment.
Besides that flat fee, ma'am, you'd agree the lowest tier, the initiates, they make a 3% recruitment bonus, correct?
That's correct, yes.
The highest tier, the ambassadors, they make more than 3 times as much. Isn't that true?
That's true. I think it's around 9%. I think you're right.
I mean, it's actually 10%, isn't it?
10%, yes.
I want to talk about whether your company pushes people to recruit. Because it's true that initiates that lowest level, well, they can become ambassadors. Isn't that right?
That's correct, yes.
They can be promoted.
Yes.
But you don't promote the top sellers.
I'm sorry, I don't know what you mean.
That's fine, ma'am, I can clarify. When you're looking at who gets to move from initiate to ambassadors, you're not looking for the top sellers, true?
I mean, I can't say that for sure, but if you're asking if we promote based on recruitment, yes, that's true.
You got there before me, ma'am. Let's walk through it. You don't promote the top sellers, correct?
Again, some of our recruits might be top sellers. I can't say, but we do we do promote based on recruitment.
Ma'am, you're not looking for the top sellers to promote them, are you?
No.
Ma'am, you're looking for the top recruiters. Isn't that right?
That's how you move up. Yes.
Nothing further, Your Honor.
Any redirect?
Briefly, Your Honor. Ms. Ruben, opposing counsel, may I proceed?
Yes, I was saying go ahead.
Oh, thank you, Your Honor. Ms. Ruben, opposing counsel asked you a few questions about recruitment. I just want to make something real clear. Do you get paid a salary to recruit?
No. We do not pay our sellers a salary to recruit. No.
And ma'am, was recruiting a priority of Worry Hater on those disclosures that opposing counsel just showed you?
No. I mean, if you look on the document, it says very plainly in bold text that the primary mission of Worry Hater and the primary mission of our sellers should be selling.
Thank you, Ms. Ruben. Thank you, Your Honor. No further questions.
No recross, Your Honor.
We just
Thank you
asked.
so much.
We just
Go
asked
ahead,
that this
defense.
witness be excused. Apologies, Your Honor.
Yes. Any objections to this witness being excused?
None, Your Honor.
All right, you are excused.
Thank you.
And defense, would you like a break? Plaintiffs, do y'all need a break before closing?
Yes, Your Honor. With that, the defense rests and probably requests a 5 to 10 minute break for closings. 10 maybe, if that's
Okay.
possible.
Let's
Okay.
stick to 5 for
5?
yeah.
Yes, Your Honor.
Guy has told us 5. We'll stick with 5.
Okay. I'll see you guys in 5.
Perfect. Thank you, Your Honor.
Are we about ready?
Yes, Your Honor.
Ready, Ron. Sorry.
Okay. Well, with that, plaintiff.
May I proceed, Your Honor?
You may.
You know, my dad, he runs an Arabic delights business. Likes to sell a bunch of Arabic sweets, like nafe, baklawa. And when he wants to market those products, he does a couple of things. He'll buy advertisement. He'll give coupons for purchases. He's been getting into TikTok lately, so he might even make a little TikTok video. But you know what he doesn't do? He doesn't ask people to join him. Doesn't force his salespeople to pay a fee every month. Doesn't just sit back and profit off of his salespeople. No. Because he's running a legitimate business. The defendant, Warhater Energy, they don't. They make their real money in recruitment. That's why we brought a claim in violation of the Midlands Unfair Trade Practices Act. Now, this case, it was a little bit different because we had two matters for you today. In the first matter, we had to prove to you that it was more likely than not that the defendant created a pyramid scheme. That's how they violated that act. And then we had to show you that Ms. Jones, she suffered injury as a result of that. But I want to be clear about something because I noticed that the defense, they brought up an important question for you today. They asked, was Warhater upfront? You see, members of the jury, we didn't actually have to prove to you that Warhater wasn't upfront. All we had to prove to you was whether or not Warhater created a pyramid scheme. Because a pyramid scheme is naturally deceptive. That's all we had to prove to you today. So that's the real question you should be asking. But that was just for the first matter. For the second matter, we also had to bring to you today clear and convincing evidence that the defendant intended to create a pyramid scheme. That's so Ms. Jones can qualify for punitive damages, but to also make sure that the defendant never does this again. We've proven both of these matters to you today by telling you this about the saleswoman, the structure of the company, and how it was all strategic. Because the real money was in recruitment. Let's take those one at a time. Let's start with the saleswoman, Ms. Jones. Ms. Jones, she took the stand and she told you that she came into this company thinking she could just sell some product and make some money on the side. But you learned today that no matter how hard she tried, lessons she took, shops she set up, he just couldn't make a profit. Now, the defense, they told you today that that was because she wasn't a good saleswoman, that that's why her sales were behind. Members of the jury, whether or not Ms. Jones was a good saleswoman, they set their employees up for failure. Let's think about this for a moment. Ms. Jones, she had to earn back that $3,500 she spent in the first place. So let's say she sold these cans at the Warhater recommended $4 a can. Ms. Jones would have had to sell 900 cans in just the first month. And that's just to break even. It's not like she wasn't doing anything. Members of the jury, she was hustling. You learned today that she sold 17,000 cans. And how much profit did she gain? 0. That's ridiculous. And it wasn't just her, because the defense they brought to you, Dylan Starr, that was their smoking gun. Told you, look, we've got an example of someone who can sell. But you learned today that Dylan Starr, just after 1 month of selling, she stopped. She gave up. She started recruiting because she knew where the real money was. Recruitment. Miss Jones, she didn't know that. She didn't know that the structure was the problem. So let's talk about that structure. Because Dr. Elmore, she took the stand today and she showed you what a pyramid scheme looks like. And members of the jury, that's exactly what we're dealing with here today. Because just like a pyramid scheme, Warhater Energy, their bottom percentage, they were losing money. And everybody at the top was gaining from them. So where do you think Miss Jones was? She was at the bottom. Because when she bought those products to sell, that was so the company could profit off of her. It wasn't to actually sell them. And you learn just how deep this structure goes. Because Warhater Energy, they promote people for recruitment, not for sales. Warhater Energy, they give bonuses for recruitment, not for sales. Warhater Energy, the top 3% of their company, they're making all the money. And it's those who recruit. So members of the jury, when a company is designed to make it where everybody at the bottom loses money while everyone at the top gains money, that's a predatory business. That's the definition of a pyramid scheme. And it was meant to be that way. We've proven to you today that the defendant's also liable for punitive damages because they intended to create a pyramid scheme. Now, we didn't prove this to you today by just having an entire trial. We proved this actually to you today with the words of the defendant before she even came, before we even had this trial. Because you learned today that the defendant, she said something. And she said it. And she thought no one was listening. Because you learned today that on a private Zoom call for the top recruits of the company, the defendant, she talked about how her company works. He said that the only way to make money is to have a team of people under you. He knew what she was saying. This company was never made to profit from the public. It was a company designed to profit off of everybody in it because the real money was always in recruitment. Now, I want to take a moment and answer that second question they brought to you today. Why did the plaintiff lose money? See, this question is actually really important because it goes to the heart of the issue. Ms. Jones wasn't losing money because she wasn't good. She lost money because she was being exploited, being preyed on. That's why your job here is important. It's your job to hold companies like this accountable. So find them liable because the real money was in recruitment. Thank you.
Thank you so much. Defense, are you ready to proceed?
Yes, Your Honor.
You may proceed.
When someone opens a McDonald's, they're joining a business. They invest in fryers, stock up on ingredients, pay employees, hoping they'll turn a profit. But sometimes, well, the business fails. You lose money. Sometimes, well, the doors, they close for good. But the fact is, that's not crooked business. That's a part of business. And when someone is upfront with you about all the risks and challenges you might face, you can't turn around and blame them when something doesn't go your way. Warhater was upfront, but the plaintiff's sales fell behind. And despite that, the plaintiff came today suing Warhater for the money they lost, but the moment they did, they took on a burden. They had to prove to you that it's more likely than not that Warhater committed a deceptive act, and that act was the direct and proximate cause of the damages in today's case, something they didn't even come close to showing. And the two questions we asked at the start, well, they show you why. One, was Warhater up front? And two, why did the plaintiff lose money? So let's start with that first question, was Warhater up front? you learned the answer was yes. You heard from a financial investigator, and he told you that Warren Hater had the government stamp of approval. He showed you this chart, which summarized each and every disclosure given about the business model, about the earnings, about the risk, and the plaintiff, well, she admitted to reading all of it. So you have to ask, where's the deception? You can't be deceived about something you were explicitly told. Well, the plaintiff was told the truth. She just decided to cover her ears. And here's the kicker. Warren Hater had a safety net. A refund programs where sellers could recoup losses on product they couldn't sell. But you heard on her cross-examination that the plaintiff refused to spend the time to comply with their policy. She was told that she had to sign a non-disparagement agreement that was a part of the policy, and she chose not to. If you really think about it, the plaintiff is asking you to do her job for her. Instead of spending her own time completing the proper steps to get a refund, she chose to spend yours on a Sunday evening asking for the same exact thing. But courts, well, they aren't return counters, and juries like you certainly aren't cashiers. Warren Hater had to prove deception, and they haven't. And that brings me to question number 2. Why did the plaintiff lose money? Because on her closing argument, Ms. Farrer says, well, she sold 17,000 cans, so she was hustling. Well, if she buys 3 times that amount, she has to be able to sell 3 times that amount. And you heard, well, the plaintiff didn't do anything like that. Today, they have to prove to you that Warren Hater's conduct was the direct and proximate cause of the damages, that nothing else contributed to them. And they didn't do it. Think about my cross-examination. I asked her, well, do you have phone records, emails contacting buyers? How about screenshots of social media posts, a single picture at a training or sales event, and over and over and over again, all she could say was no. My little sister puts in more work selling Girl Scout cookies. And even at 12 years old, she understands, well, it's not really great business to consume product you're supposed to be selling. Warren Hater was out front. So you can't blame them for the plaintiff's sales falling behind. And that brings me to question number 3. Well, I didn't tell you about this on opening statements, but Ms. Farrer, she brought up important questions. And what this case comes down to is whether or not Warren Hater was a pyramid scheme. And the one question the plaintiff had to answer to prove that to you was whether or not participants made most of their income from recruitment over sales. And that's something they couldn't answer for. Because sure, they brought you Chris Rone, someone who's only here well after they realized the business of bashing a business pays quite well. Is it more likely that a CEO let a random stranger onto a Zoom call, or that an influencer with no proof is making a story up to stay in the spotlight? Well, then the plaintiff, well, they point you to Exhibit 2. They said higher ranked people earn more, so the money, well, it must be in recruitment. Isn't that jumping the gun just a bit? Because yes, Warren Hater gave out bonuses for recruitment. Newsflash, that isn't a crime. They had to prove that that's where sellers got most of their income, and they couldn't. On her cross-examination of Mr. Vasudan, well, Ms. Tang asked him, you only looked at a couple pieces of financial documents. So did their own paid expert. And when confronted with Exhibit 2 on the stand, that expert couldn't tell you the majority of any of those figures came from sales versus recruitment. I mean, doesn't it make sense that the people who have been in the company longer earn more? That they have more experience, that they're better at selling? I mean, do you ever look at a line cook and a head chef and think, you know what? It's not really fair that one makes more than the other. No. They want you to assume that the money is in recruitment without giving you the evidence to back it up. And that's because it does not exist. Business is a risky game. Sometimes you're a success. Sometimes you're not. Sometimes you make good decisions. Sometimes you miss the mark. But the real money in this company wasn't in recruitment. The real story is that the plaintiff bet on herself. But not all bets pay off. War Hater was up front, but the plaintiff's sales fell behind. Find them not liable. Thank you.
Thank you so much.
Rebuttal, Your Honor.
Oh, yes, rebuttal. Yes.
May I proceed?
Please proceed. Yes.
They put their recruits up front and left their sellers behind because the real money was in recruitment. Find them liable. Thank you.
Thank you.
Once each scorer is done with their ballot, that means every score is filled out. You can come on screen and just give me a thumbs up or put that you're done in the chat. Thank you, Dennis. Once we see everyone, thank you, Murray. Thank you, Anna, thank you, Gelf. If the reps could go to the tab room and start checking those and then messaging Sam. Thank you, Will. I see a thumbs. Thank you, Ria.
I'm done.
Thank you, Congresswoman. Oh, we're going to. Thank you, Travis. Okay. I think everyone got bumped to breakout rooms, so let me just close this real quick. Welcome back, everyone. We are going to get started with judge comments while our tab reps count the ballots. So, Congresswoman, if you'd like to start, the floor is all yours.
Thank you. Y'all, I had so much fun. Sorry that I look sleepy because I am. So hopefully I didn't miss anything. I was really intrigued. So first of all, I think the plaintiffs did a really good job on their theme. I heard it immediately out the gate in opening. And then I absolutely heard it harped on over and over in closing. So fantastic job. If I had to rule, I'd actually rule for the plaintiffs. And I'm a defense girl. But it was because I felt like you knew what your mission was, and you attacked it really, really well. I also think that y'all handled your objections really well. You seem to understand them maybe a little bit beyond just what kind of was provided, but you kind of understood. There was the point in which I said you may be able to get it in about the 10,000, and it was the CEO, I think, that it said it. Do you remember that part? I'm sure you do. What I was trying to hint at you is that because it was my understanding that the witness had interviewed the CEO, so therefore the witness should have had that information. So I thought you could have just, yes, and in the interview he stated such and such, correct? And then you may have drawn an objection as it relates to hearsay, but there is an exception to that because it was part of the investigation. So yeah, that's where I thought you'd go, but I think that you actually wiggled your way out of that pretty well. There also was the probative versus prejudicial objection, and I overruled it, but I probably would have allowed for hearsay to be sustained on that one. And the witnesses, oh my God, Miss Starr. Miss Starr was insane. Absolutely loved Miss Starr. She even added the kids in. It was fantastic. And definitely defense attorney number, I don't know what your number was, but you did the first direct on y'all's case in chief. Is that right? Who did the first direct on the case in chief for defense? Are you there?
I think that was me.
Is everyone? Yes. You, yes. You actually want to go to law school. Yes?
Yes.
Yes, I can tell. Yes, I remember people like you when I was on mock trial. No, you did a fantastic job. I know that you probably were not happy with my one ruling, but I don't know if you fully understood where I was coming from. That one, what was it that you objected to? Do you remember?
On the
And
defense,
I overruled you. It was the testimony.
I forgot it all now. I'm trying to put it out of my mind.
Yeah, no, but it was, you did really well. I wanted to explain it better about how that rule is applied, but I don't remember now. But either way, you did a really good job of arguing everything that you argued for, which you did your fair share arguing. It was not too much, though. I think that you did really well with making sure that you didn't do too much. And my closing attorney on the plaintiff side. Are you there?
I am sorry, I didn't know you could see me at the top bar. Hello.
Oh yeah, I don't have it set up that way. No, I loved actually what you as well as defense closing attorney did. One thing that y'all did was y'all made it personal. You made it to where a jury could be like, oh, okay, right? So we had the little sister with the Girl Scout cookies, which I thought was hilarious. And I thought you may actually go further on that one and say, because Girl Scout cookies aren't sold in like the stores, they send out little girls to sell them. So honestly, I thought that you may play around with that just a little bit. But I love to hear about your dad's store and how you plugged it into the overall scenario. I think that took it out of kind of the more complexities that go along with kind of like this type of structure. And it made it something to where even if you had the everyday person who had never been in a corporate boardroom or anything, you made it to where they could understand. And oftentimes in juries, you're going to have just kind of a wide array of people. So those are my pretty big highlights. I will let the other judges speak because obviously I have been speaking the entire time. So thank you so much. You all did a fantastic job. Super excited to see where all of you go because you all were absolutely fantastic.
Thank you, Congresswoman. I'll pass it to Dennis Kerwin.
Oh, hey, hi. I'm also going to take this opportunity to say hi, Jasmine Crockett. I'm a big fan. That's all. So thank you for being here. That being said, overall, y'all, this was a good round. Like, I am not even gonna sit here and try to pretend like, oh, this is nitpicky and all the little things, also knowing that at the end of the day, like, y'all aren't competing with this case anymore. But it was fun watching the case that I helped write come to life. What I want to talk about are things that I think can benefit you as you compete in mock trial moving forward. And the thing that I really think both teams need to think about moving forward is your time. I really think, Morgan, you're a freaking powerhouse. Like, I think you are brilliantly hilarious. You were on the stand for direct for like 2 minutes, and I was like, ooh. And like, it was hard to score you on that because you were there for such short time, but you were so powerful. And so when y'all are thinking about this, like, recognize that when you have something that gets so lopsided on the times, like, that ultimately changes some of the scores on the ballot of how do you score those things. Defense, on the other end, I think some of your crosses were a little lopsided in the amount of time that y'all had on those. So again, that time component comes back into play here because I'm looking at how am I scoring these things side by side? How am I putting them next to each other? And so really think about that, really making sure that you're able to get in, get out, get things done, make sure the witnesses are coming across in a powerful way is really going to be the difference. Typically, I know where my ballot falls by the time it gets submitted. My ballot is super close, like safely the closest ballot I've submitted in a very long time. And so I genuinely do not know which one of you won my ballot. And honestly, I think either team that gets announced as a champion is well deserved. Please pat yourselves on the back. Y'all did incredible. And I'm still Jasmine Crockett's biggest fan. The end. Thank you.
I'm going to pass it to Ria Lakaraju, who I'm going to give an extra shout out to. Just got back from Singapore yesterday, so thank you for being here despite the time change.
Yes, I am quite jet lagged, but what a good way to be welcome back to the USA. This was a really, really great round. I echo everything that everyone else has said so far. Just such a high caliber round, which is so nice to see. I really don't have a lot to say in terms of room for improvement. I think you all already are showing so many of the traits that are present at the highest levels that you see it nationals, so on. But I hope that you all know that. The only thing I can really think is my favorite moments from this round were the ones that you all sort of took yourselves out of the case file and just put us in the shoes of like the logic of the moment, like does this really make sense, period. Arguments are my favorite. So like keep doing those things as you go on. I think you'll find that like those set you apart from a lot of competitors and just make everything so much more digestible and entertaining to watch. The one piece that I think could use a little bit of improvement is sometimes this is a theory point. I think moving forward, there are times when you'd say things that didn't necessarily on both sides. You'd say things where I'm just like, what is this? Where does this fit in your story? Where does this fit in your arc? And if it doesn't fit, then just trash it. Like sometimes the extra thing isn't always worth it. It's just like eating up time that you can use to showcase like a better strength. So just really be mindful of like, is every single fact that I'm presenting, is every single argument and leap that I'm drawing something that will come back in the close? Is it something that is like directly related to our theory, or is it something that just like looks cool, sounds cool, etc., that like we think might be helpful, but like requires an extra leap in logic, like an A to B to C type thing, as opposed to like those direct connections? Because there were a couple things where like I saw the leap maybe, but it just sort of added on to like a case that and convoluted things a little bit. So just be mindful of streamlining. But other than that, I thought everyone was great and presentation was fantastic all around.
Travis, I will go to you next.
Hi guys. Amazing job. Thank you so much for like putting on such a great trial. It's 10 p.m. on a Sunday, but I'm honestly energized because that was a really fun round to watch, especially over Zoom. And I think the biggest thing that contributed to that I want to shout out the most is that this was an excellent witness round. Excellent witness round. Like one of the best witness rounds I've seen in a really long time. Like I was so deeply entertained. Like all the witnesses on both sides were like actually amazing. And I think one big thing for me is also natural. Like it can be very easy to just be like super off the wall and funny, but like they were very grounded, funny people that I could imagine seeing in my day-to-day life, which is something that I really enjoy. And even the witnesses that like aren't like off the wall, like I love both of the experts also. I thought you guys had such natural and like endearing and like commanding characters. So yeah, I just want to shout out the witnesses. Y'all were epic. The other thing that I really enjoyed were the openings. I thought this case was really complex. There's a lot going on here. And and I think I had never seen this case. I never read this case. And I think there was a lot to take in, and I think the openings did a good job doing something really hard, which is synthesizing like both a lot of law and a lot of facts into like also what felt like shorter openings and like general amped openings. So like that was really great while also being like really performative and really getting to the like I think the moral high ground that both sides were trying to really encapsulate, which I think is kind of the hard thing about theory, not just like actually and factually why you're right, but like why you should like sympathize like with my client and like my side of the facts. And I think that both sides did a really good job of doing that. And so yeah, I'll just leave it at that. Keep doing what you're doing. I'm sure I'm gonna see a lot of you again, like on the circuit doing amazing things, winning awards. So yeah. Thanks again. Have a great night.
I will pass it to Murray Edwards.
Hi everybody. You guys were phenomenal. The fact that you guys are like freshmen and sophomores is crazy to me. There's no world in which you guys should be considered rookies. You guys are excellent. So that just means that by the time you graduate, I mean, you're going to be like scary to compete against. So really kudos to you. I think my biggest like thing that I wanted to see more of, I guess, is a little bit more of like performance and like changing in your tone. So like I mean, you guys know the content. There's no question about that. Like, you guys know objections, you know all of that. But think about the way that you're saying the things, like, you know, speed it up, slow it down, get louder, get softer, like really play with that, especially on Zoom, because I mean, we're listening to you. We don't get to see as many of the hand motions as we would in person. But I think that everybody, like, if you could just like play with like, how can I make my voice sound different and like reflect different things? Like, I think one really good example of it was on the plaintiff closing when you were talking about like, you know, the secret that the CEO said. Like, I think that is like an excellent example of like, you know, matching the voice to like the content of what you're saying. I really loved that. But I wanted to see more of that throughout the trial. But that's a really nitpicky thing because you guys were off the charts. And especially I wanted to give a shout out to, I think it's Emberlyn. I don't know if I said that right. Every time you came on screen, I knew you were about to say something phenomenal. I loved watching you. I loved watching all of you. But I did want to give that special shout out. But overall, good job. Cannot wait to see what you guys do in the next few years.
Thank you.
I will throw it to Michael Gelfand.
Hi, I want to echo all the positivity. I made a lot of written comments, so I'm going to be very, very brief. The one, I really, really appreciated the energy for so late at night. I was very, very pleasantly surprised by the level of energy throughout the entire round. The one big thing I think can be improved on almost every witness, there was an obvious thing that was going to be crossed upon that probably should have been fronted on direct examination. There were several points that I was legitimately surprised by and detracted from the witness's credibility, where had those things been fronted on direct examination, I think it would have taken a lot of the sting out of it. But other than that critique, I think overall was an excellent round, especially for first and second year people. And it was tough to differentiate with the teams, and all of the critiques I wrote should be taken with that constructive thought in mind. Congressman Crockett, it was a pleasure to see you preside, especially a week after I saw that viral video before the Judiciary Committee. I thought you were an excellent presider, and I was really, really thankful to be here for that. Thank you.
I will pass it to Anna Eldridge.
Sorry, I was muted. And my dog is going crazy, so I'm going to keep this pretty brief. One, I also have to shout out Representative Crockett. I don't know if y'all caught this. We went to college together 2 years ago to count. And so it was very cool seeing you back in this environment. I'm sorry my dog's crazy. I'm going to turn things over to my written comments for that reason. Really impressed. I'm going to leave it here.
Will Warhay.
Hey everyone. I mean, I echo everything that's been said by everybody else. Y'all are fantastic. I think the only thing I want to highlight is really what was my favorite moment of the trial, which was actually it was Miss Stinson, your cross of you, Miss Soundy, and this was for both of you. A very obvious bad fact for your character, Morgan, and you leaned into the camera, you had the answer ready. And Penelope, you just went straight with it. You leaned right into, you had this little smile. You kind of like it was such a good, fun moment for both of you. And I think it just encapsulated the round because you both were throwing punches and each side was ready to meet and match in response. So y'all should be really proud of yourselves. Also echo Congresswoman Crockett, thank you for being here. It was an honor to see you and I agreed with every one of your rulings. I thought you did great. So thank you.
And we will finish it off with our Madam President, Jacinth.
Hey, everybody. Conveniently, I had very similar opinions to everybody who went before me, wrote a lot of comments. I think it was very clear, as Dennis said, this round was so evenly matched that it's very clear why you all are in the final round. I did not think I was watching Rookie Rumble. You could all easily be at Orcs, did amazing. Also, Travis, your comment about how epic the witnesses were, that was so true. And I think that on the cross-examinations, watching the rapport back and forth was really enjoyable. Congratulations, everybody. I know it's incredibly late, especially for you on the East Coast. And so I think that we can probably, Adam, hand it over to Tab to see who our champion is.
Will do. I will be the Tab rep to share our results. And before I do, I want to give a shout out to the two teams. On the plaintiff, representing UCLA, Team 12. And on the defense, representing Team 48 from UChicago. This was a very close round. It was a split decision, 6-3. The winner of the 3rd annual Rookie Rumble is Team 48 Chicago. Congratulations. Thank you, everyone who was watching. Thank you, all the reps who helped out. Thank you to all the judges. Thank you to the final round competitors. We will see y'all next year.